We know that you well serve the cause of justice in this circuit. For anybody who's really eager and wanting to jump up to the podium right now, today is not that day. We hope it comes very soon. Congratulations.
This concludes the attorney admission ceremony. Thank you. Calling case number 25-1159 et al. People of the State of Michigan petitioner versus United States Department of Energy and Christopher A. Wright, Secretary, United States Department of Energy. Mr. Wilkins for the petitioner, State of Michigan. Mr. Shaggy for the Public Interest Organization petitioner. Mr. Standard for the respondents. Mr. Schultz for the intervener, Consumer Energy Company.
Jim, can I please get the court sheet? Yeah. Good morning, counsel.
Good morning, Your Honor.
Wilkins, please proceed when you're ready.
Thank you, Your Honors, and may it please the court. Lucas Wilkins appearing here today on behalf of Michigan Attorney General Dana Nessel, as well as the other state petitioners in this case, Illinois and Minnesota. The department's claim of authority here is unprecedented, and if unchecked, would transform the structure of power for regulating resource planning as it has been commonly understood for decades. The emergency clause of Section 202C presents a limited exception to a general reservation of state authority. The section's plain language, past interpretation, and context make clear that its exercise is constrained fundamentally by the existence of an emergency. That is to say, conditions necessitating immediate action by the Secretary. The department instead asserts that it is unbounded in its application of 202C, that it can use the emergency exception to undermine years-long resource planning frameworks without consideration for whether the Secretary's immediate action is needed. That reading would allow the exception to swallow the rule, leaving all resource planning decisions subject to unilateral override by the Secretary with no limiting principle. In turn, it would allow the department, as it has here, to interrupt and frustrate a finely calibrated system of overlapping regulatory processes, including the application of state statutes, the planning and cost recovery practices of utilities, and the entrenched rules of system operators, along with FERC's regulation of those rules. The court should thus hold that the department cannot use its 202C authority here and set aside the order on that basis. The department has further erred by failing to present substantial evidence to support its emergency determination and by failing to appropriately tailor its order to address any emergency, which present independent bases for holding unlawful and setting aside the order.
So can I just ask a question so you can appreciate where the parties are on what constitutes an emergency?
Sure.
If there's a danger, a risk of harm that's off in the future, but the actions needed to address that risk are ones that need to be taken now. So there's immediate action that's necessary to avert a risk that's going to germinate in the future. Does that constitute an emergency from your perspective?
So no. I mean, in terms of a long period of planning where there is a potential for an emergency years in the future, that is within the realm and ambit of existing regulatory processes.
Definitely, if you say it's a potential for an emergency, then you don't have an emergency now. I totally get that point. I mean, I get the question. If it's a risk of a significant shortage, but the shortage isn't going to happen for a little while. But in order to avert that shortage from happening in a little while, there needs to be immediate action right now. Would that constitute an emergency?
So no, and that's because we have so many regulatory processes already in place to address that. And I want to talk about that for just a little bit. You have to keep in mind, we spent time in briefing talking about the role that the Public Service Commission and utilities play from integrated resource planning, as well as a system operator performing, studies to make sure that retirements are okay. But you also have to keep in mind that MISO's tariff is regulated by FERC. And FERC has the ability to undertake efforts to attempt to steer resource planning if it so chooses. And furthermore, the secretary himself has the ability to influence that process through Section 403 authority. He can ask that FERC undertake those methods as well. So you understand that there's a breadth of mechanisms starting at the state level, but including federal regulation that act before the secretary's specific emergency authority kicks in. And that makes sense because his power under 202C is extraordinary and that it provides no procedural safeguards of notice and hearing. And I'll say as well, the Otter Tail case that we looked to, Otter Tail Power we looked to in briefing, explicates this scenario a little bit better. So in that case, it was expected that a small utilities load would increase in just a year or so, such that it would start to run an acute risk of load loss. The Eighth Circuit, in that opinion, described that the load loss event, as it would occur in a year or so, would be an emergency condition. It described it as such. But at the time at issue, that is to say, a year or so before any such potential load loss event would occur, the court identified that a resolution did not necessitate immediate action by the secretary, and therefore that 202C did not apply. So the point being there that even in a context where, as in that case, not this case, in that case, where one could certainly say that poor planning by utility would be a underlying cause of a potential future emergency, the court did not assess the planning itself to be an emergency necessitating immediate action. And instead, it looked to 202B, which does preside procedural safeguards.
That's a situation in which there wasn't any immediate action necessary, just even by the way you've described it. And I think, I'm not sure there's any disagreement that if there's no immediate action necessary, then the circumstances don't present an emergency. I guess the question that I'm asking conceptually is, the risk and the harm that's going to be visited may be off in the future, but it may be a situation in which immediate action is necessary to forestall that risk. And what I'm wondering is, if you don't think that that qualifies as an emergency, and it sounds from your answers that you don't, suppose one were to think that that is an emergency, that if you have a circumstance in which immediate action is necessary to forestall a risk that's going to germinate down the line, if that would qualify as an emergency, does that mean that you can't prevail in this case, or do you still have an argument that you can prevail even if it's a certain circumstance in which immediate action is necessary? I mean, you may well have an argument that actually this is not a situation in which immediate action is necessary. I totally understand that. But I'm just wondering if one thought that this could be described as a situation in which immediate action is necessary to avert a harm from coming to fruition down the line, then where are you in the case?
I'm not sure the theories around such a circumstance where there would be an immediate, and to be clear, that is not this case.
Okay.
And I want to talk about that more in a minute, because it has to do with the confines of how the department has described the emergency it's asserting here. But theoretically, if there were a case where there was literally nothing else that could be done other than to undertake action in the present to avoid a future point, and I'll say too, we're speaking in relative terms. Right. Yeah. Like I'm not sure what time you're describing, but fair, yeah. Theoretically, maybe that could be a case, not this case, but a separate case where you could describe an emergency authority. But I want to be very clear that the court doesn't have to go drawing lines in this case around where imminency stops and starts, because as I kind of previewed there a second ago, the government is saying that, the respondents are saying that they're not confined whatsoever to an imminency component when they need to act. They're saying they can identify generalized conditions spanning years into the future across huge swaths of the country, and furthermore asserting plenary authority to determine when those conditions exist. So the court here doesn't need to draw lines around when imminency stops and starts. All it needs to do on the statutory interpretation question is say that the respondent's position on that point is wrong, and it does not justify use of 202C here.
I think perhaps to follow up on the Chief Judge's question, it seems that there's a lot of ink spilled in the brief about, definitions of emergency in various dictionaries and statutory contexts. And one of the arguments or points of disputes seems to be on whether to be an emergency, something has to be kind of unforeseen or unforeseeable. And I think, at least what the Chief Judge may be getting at is something that I've thought about as well, which is something like climate change. Is climate change an emergency? A lot of people would say that it is. It's not something that is going to result in devastation, according to scientists, tomorrow, but in the future, and therefore you need to take action now to avert that risk, or anything else that you can see coming down the road, but you conclude you have to take action now to avert the risk. It's not unforeseen because we know what the risk is, So if something that's foreseeable that you have to take action now to avert, is that an emergency?
The emergency, the application of 202C steps in when it is needed for the secretary to act under that specific section. And that's because it exists, within the context of the statutory scheme where we have all these other processes, from a state level and also integrated with federal oversight that serve as a planning mechanism. So in the climate change context, for example, in the context of 202C, where we talk about where the secretary needs to act under that, may be required to act immediately under that section, it would not be an emergency in that context. Now, I would hope that the other regulators that have these long-term planning responsibilities under the statutory scheme would take it seriously and proceed with, a sense of urgency to correct that. But in the confines of Section 202C, that is simply not the case.
So I guess in writing an opinion, should we say that the meaning of emergency is an unforeseen circumstance? Or can an emergency be foreseeable circumstance, but it's an emergency because you have to take action on an exigent basis?
There could be emergency occurrences that could be somewhat foreseeable. And that is, for example, in the context of the otter tail case that I described, where they could tell in a year or so they were going to run a risk of emergency. But the underlying principle that's at the core of all the adjectives we glean from dictionary definitions, past interpretations of the statute, and otherwise, is an immediate need for the secretary to act under that section.
So you believe that exigency is really more relevant or important to defining emergency than foreseeability?
Yes, and we stress imminency in the briefing, but I think we're saying the same thing as far as you're using the word exigency.
But it seems like you're adding one gloss to it, which is that you think that an emergency is when there is an exigency, as was described, but even the existence of an exigency wouldn't be enough to constitute an emergency for 202C purposes, because you think it has to be, and this may, I'm not meaning to express skepticism, I'm just wanting to make sure I understand your position. It has to be an exigency as to which DOE has to act, meaning that there can be an exigency as to which someone else could act and avert the harm that could occur down the line. But you think under 202C, it requires more than an exigency. It requires an exigency as to which DOE is the only entity that can take action to avert it. Is that the way you think?
That is correct. Sorry, I interrupt you.
Okay.
Yeah, yes, that is correct. And in part because I described, because there are already so many tools at play, including at the department's own disposal to influence planning and averting emergencies well before that extraordinary remedy without procedural safeguards is necessary to step in and play a role.
So I guess my question is, sorry, there's one quick follow-up. My question about that is, why would we think that Congress would have thought, if there's a circumstance that constitutes an emergency, at least in the sense that it requires immediate action. So it's an exigency, requires immediate or imminent action, even for a risk that's going to come to fruition down the line a little bit. And if there's other players who could also take immediate action, someone's got to take immediate action. There's various immediate actions that could be undertaken, but someone's got to do something and right quick, because otherwise we're going to have this serious risk down the line. Why do we think Congress would have thought that DOE should be disabled as long as it's possible that someone else can handle it, as opposed to a Congress saying, if it's that kind of circumstance, I just want to make sure that somebody acts, so I'm going to go ahead and let DOE do it. And then if there's duplicative efforts and we're just having a lot of folks react immediately to an emergency, I get that comes at a cost, but I just want to make sure that the emergency is covered.
Well, we can understand that from the structure of the statute. And that is to say, we start with the applicability section of 201, which reserves the general authority over generation planning to the states and provides for only specific exceptions to that general reservation of authority. And we talk in briefing, and I think I mentioned in opening here, sort of conceptually how a unilateral override would allow the exception to swallow the rule. But there are practical consequences to that as well, which potentially Congress did envision when they were setting out the statutory framework. I mean, for one, a unilateral override would interfere with the ability for regulators into systems that have been developed over decades to understand how much capacity will be on the grid or will be needed on the grid at any point in time. And the consequences of making mistakes in that context entail incredible costs. We're seeing that with Consumers Energy here. You know, they're reporting well over $100 million in net financial impact for continuing to run the Campbell plant pursuant to a 202C order. And that's not surprising because their own expert forecasted that they would save ratepayers well over $300 million from foregone capital expenditures, major maintenance costs.
So, Mr. Wallenstein, just the same issue, I just wanted to probe a little bit more. I take your position to be, in response to the questions that have been posed about if it's something that may not come to fruition for a while, but if it does, if there's not action now, it will be an emergency. I take your response to be that 202C is only available if that it's sort of a last resort and it's structured into the statute as a last resort, and that imminence is in fact the sine qua non because there are all these layers of longer term planning, and DOE has a role also in triggering that. So if you have a region that is failing to do planning and you say, whoa, if they're continuing on this path and not seeing, you know, the percentage risk of, you know, huge megastorms because of climate change or something, that's not an occasion to use 202C. It's an occasion for the Department of Energy and FERC and the regional planning apparatus to be, you know, prompted to act more constructively with respect to that. So it is my understanding that you're basically saying this is a last resort for good reasons. And I actually thought that the energy law professors, energy law scholars were laying out the point that I think you just alluded to, which is if you get this sort of, you know, diving in to the middle of a long-term planning process, then all the variables shift and you end up with sort of environmental and price bumps that are just, it ends up just sort of being a free-for-all. And so there's the reason why this is a last resort tool is because you don't need it. If you have all this long-term planning, you know, you have a market that you can use at the last minute, you have capacity, you have excess capacity, you know, and the whole planning process is a lot of anticipating of unanticipated factors. And so if you're thinking that there's going to be a problem down the road, you route that into the ordinary planning process. Is that right?
Yes, Your Honor. And I want to emphasize one more point I don't think you touched on there, which is that the existing processes are also just simply better positioned to address these resource planning questions. And the department acknowledges as much in the resource adequacy planning report, where they state that DOE acknowledges that the resource adequacy analysis that was performed in support of the study could benefit greatly from the in-depth engineering assessments which occur at the regional and utility level. And they go on to say as well, however, entities responsible for the maintenance and operation of the grid have access to a range of data and insights that could further enhance the robustness of reliability decisions, including resource adequacy, operational reliability, and resilience. So there are for a variety of factors here, for a interference with process reason, from the incredible costs that are entailed with making mistakes in that process, and from just a straightforward capability reason, it would not make common sense to give the Secretary a unilateral override as to the robust and intricate processes that currently exist for resource planning.
I took you to be having some hesitation in answering the prior questions. And is there anything behind that? Or, I mean, it just seems like if it's a last resort, that's just, you know, that's just the case. But is there a pushback there or a precedent that doesn't line up with?
My hesitation was really about line drawing, and I think it's easy to get into a line drawing question here. But as I said, you know, earlier to Judge Srinivasan, this case really is not about that, because the department's position is fundamentally opposed explicitly to any concept of imminency being a requirement whatsoever for the exercise of 202C authority.
Make sure my colleagues don't have additional questions at this point.
Thank you, Your Honors. I'll pass off argument to my colleague from the public interest organizations.
Thank you, counsel. Mr. Shagnon.
Good morning, Your Honors, and may it please the court. Ben Shagnon for the Public Interest Organization petitioners. I'd like to try to reserve 3 minutes for rebuttal. So I want to pick up right where the questioning left off, just to make clear that this case isn't about whether the grid faces challenges or whether they should be addressed. The real question is who has the authority to address those challenges and how. And getting to this exigency point and last resort point we've been talking about, in most usual cases, other actors have the authority to address these problems, not the Department of Energy. They really should serve to exist only as a last resort. And so to take
And does that mean, just to get the lexicon right, does that mean a last resort in the case of an emergency? So first layer is there an emergency? Yes. And then the second layer is, even if there's an emergency, DOE can only come in as a last resort. Is that how you understand the statute to work? Or are you saying?
Yes, that's right. So I think everyone could agree that there's a problem that needs to be solved, and everyone could agree that it would be most prudent to start solving that problem right now. And then there's this further question of which tool in the toolbox should be used. And very rarely should the answer be the Department of Energy's tool.
But I think that's a different answer from what the chief judge was proposing. I mean, you can speak for yourself, but if I were asked, does last resort mean, assuming there is an emergency, DOE can only come in as a last resort? I would think it's not an emergency unless it's a situation in which DOE's last minute intervention is needed, because an emergency is the thing that triggers 202C. And what I understood your colleague from Michigan to be saying is there are important problems that could cause a lot of difficulty down the road that we take very seriously. You know, new demands for energy, storms, high heat situations. Those are not emergencies because there are layers and layers of long-term planning and lots of expert actors that are actually thinking about those today. If they're not, then you don't use emergency power, but the Department of Energy, FERC, can come in and say, you're not looking at something important.
That's right, Judge Pillard. So you might think that it's a pressing problem, but we wouldn't call it an emergency in the Section 202C sense, because what Section 202C's emergency is talking about is those circumstances where there's a pressing necessity for the department to act, not just anyone to act. And so we're thinking about this climate change hypothetical that Judge Wilkins raised. There might be a need to act in the present, but there wouldn't be a need for everyone to act in all ways right now. We would want to use the normal processes that are set up to address that kind of challenge. And to think of just an ordinary everyday kind of analogy, if we're driving along in a car and we decide, oh, we need to stop at this red light up ahead, I think we would look first to the regular brake, not the emergency brake, because we tend to use normal mechanisms to solve problems before we go to extreme ones. And as my colleague from Michigan made clear, there are features of this system that do make it the extreme option. We can look to the facts of this case where Consumers Energy was set to retire this plant. And they took a lot of steps to make sure that it would work. They went and bought and acquired an entirely new gas plant with 1,200 megawatts of capacity. And all of that is for naught if that planning exercise, that extreme planning exercise, makes little sense if Campbell was going to stick around anyway. So it's corrosive in that sense, but it's also corrosive in the sense that the department recognized in its original 1981 regulatory preamble, where it said, we're wary of jumping in to do long-term planning ourselves because we don't want people to think, we don't want utilities to think that we're always going to step in and solve their problems. Long-term planning is their job. We think they're best positioned. Congress required them to take on the mantle of solving these long-term issues in the first instance. And that makes sense for all the reasons my colleague from Michigan made clear, which is the state planning process, for instance, has in Michigan has a 5, 10, 15-year forward-looking procedure where they figure out what's load going to be, how can we best address it, what policy decisions we want to make around that. That isn't present when you use 202C. Likewise.
So can I ask this question? So suppose you have a situation in which yes, in theory, it's possible that other kinds of interventions and planning by other entities and institutions can redress the looming harm. But DOE looks at it, and I'm not saying this is this case. I'm just trying to understand how the statutory scheme works in the abstract. And the DOE looks at it and says, yeah, that actually in theory could work. I'm just investigating this, and I don't think they're doing it in the right way, or I don't think it's happening with sufficient exigency. At that point, is DOE free to use 202C to step in, or is DOE supposed to use some longer range tool that it can have, maybe under one of the preceding provisions, to spur the other processes to act in the way that DOE thinks would be necessary?
So no, they shouldn't be doing that. As Judge Pillard's earlier question.
That being 202C,
they shouldn't be using 202C. So one example of what they can do, and we haven't focused on this on the briefing, but there's 42 USC 7173, which is part of the Reorganization Act, and it empowers DOE to tell the actors, the FERC, that it should engage in rulemaking, for example. So if it doesn't think that MISO's tariff is getting the reliability or resource adequacy job done, or if it doesn't think NERC is getting the reliability job done, it should tell them that and say, your analyses are no good, please revisit these questions. It can also—
You cited a statutory provision, which was?
42 USC 7173A.
How about anything less cumbersome than rulemaking?
So they can also issue the kind of report that they issued shortly after the initial order came down, where they can analyze the problem and inform folks. And separate from DOE, it's not that the federal government is without tools to solve these problems. There's the NERC, which is an independent entity, but it is organized and supervised by FERC. As part of that process, they've set over 80 mandatory reliability standards, including establishing the 1 day in 10 years risk standard that animates the entire industry. You also have FERC supervising MISO, who's the planning coordinator at issue here, who's doing all of these analyses that DOE is looking at in its order and finding no real reason that they are insufficient.
Tell me a little bit about if the Department of Energy comes in under 202C, is part of what happens is that the pricing and demand analyses that are in the long-term planning, like other generation sources, like you're going to be relied on this amount, that just gets upended. So you might end up making a different source of energy, the new natural gas plant that they brought on, to make that actually no longer financially viable because they're prioritizing the output from the legacy coal plant. I mean, tell me a little bit more concretely about the destabilizing impact of the kind of parachuting in on long-term planning by the Department of Energy post hoc.
So there's the set of problems you describe. If we also look at the kind of planning auction we have that MISO did here and that the department looks at, all of that is trying to figure out exactly how much capacity we need on the grid, in part to determine what prices might be and what signals that should send about future investment. It's hard for first-line investors who are trying to build this capacity, utilities. It's hard for state regulators. It's hard for MISO to know exactly what role Campbell's going to play. One feature of the department's order here is it identifies this open-ended emergency that we don't think there's any pressing need based on what the record says, but they also identify no criteria under which it might end. So it's very difficult for anyone to plan because right now there's potentially up to 1,560 megawatts going to be on the grid. That crowds out other investment or other opportunities to add other stuff to the grid. And one of the core problems that the department cites in its brief is there's this ongoing effort to interconnect more generation to the grid, and that becomes more challenging unless you have a complete picture of what's already there. So I'd just like to offer a few more words of comfort about why adopting the rule we're talking about won't upend society. So the first is, if you look at all of the historical examples that are cited in our brief, in the state's brief, and even the government brief, adopting the line we've described here and worked through with your honors would not require any of those orders to be undone. So it's really just starting with this order and the subsequent orders in other areas of the country that are doing this long-term planning. But even the Morant case, which is this 2005 case about this area of the country, that we think would be perfectly acceptable because there was an imminent need for the department to act because there was going to be a shortage or a real risk of a shortage of losing electricity in downtown DC. This Yorktown order from 2017, similarly, there was an imminent risk as the department clarified in its rehearing order that over 150,000 people might be without electricity unless the department acted. So even in those cases, which were thought to be on the outer edges of Section 202C, we think those would fit comfortably within our rule. The second thing is just to make a little bit clearer that even if some of these long-term challenges aren't addressed, I do think it's important to note, and this is reflected in our briefing, but also in all of the work MISO does, that there are very compelling ways for MISO to react to short-term problems, and they do this all of the time without going to DOE for help. And they can do very common sense things like if there are plants being maintained optionally, we suspend optional maintenance. We can get imports from neighbors. And we can do a bunch of other things like that before we ever activate the extreme remedies that the Department of Energy can provide.
And then it sounds, if you have one more point, you can make that quickly and then we'll give you some rebuttal time too, but.
Absolutely. And so I think what that all shows is just that it's very unlikely in this sort of imminence concept that's very common in the law that all the department has is speculation that these things happen, but they haven't worked through, they haven't done the work to figure out that the harms they fear are going to happen with a certainty because all of these other actors are doing their best to solve these issues.
Make sure my colleagues don't have additional questions.
I just have one, and I know the language in this area is specialized, and we'll hear from the department on this too. But, the department in its order identifies potential tight reserve margins during summer 2025, elevated risk of operational reserve shortfalls during periods of high demand or low resource output. And the MISO planning resource auction results say new capacity additions were insufficient to offset negative impacts. They said just like it's all there admitted that there are shortfalls, gaps, potentially tight reserve margins. Is there anything about the terminology that it sounds bad but isn't, and that you can tell us why that squares with your position?
So agreed that it all can sound bad potentially, but none of it is bad. So starting with the tighter reserve margin, a reserve margin is set in the first instance by MISO to achieve the standard of risk tolerance that the overall system uses. And then they achieve a margin on top of that, a buffer on top of that to make sure that things are extra reliable. And even still, there was a surplus of generation beyond that. The government makes a big deal about how the surplus has reduced, but there's nothing magical about how much surplus one has. In fact, having too much surplus can be a bad thing because that can mean that you're paying more for electricity than you might, or generating more electricity than you might otherwise need. And in terms of all these statements saying new capacity hasn't made up for some of these losses they're describing, in some ways that's the function of the auction. It's in part a planning tool, what capacity we have, and this is present in the auction results itself. It's also a tool to tell investors, hey, it's worth investing here. More capacity will be needed going forward. We think there's real room for you to take advantages of these higher prices and come on in. So it's a planning tool in both of those senses. And MISO had specifically tailored its auction results to achieve that kind of end, to more accurately reflect these dynamics. And as for the NERC assessment, it often says things like you might need, there's elevated risk, and so there's a possibility of shortages in some sense. But what the NERC assessment says, and this is at page JA 118, when talking about the MISO region in particular, it says things like, that is mostly a risk that you will have to go into all of these mitigation measures I talked about using things like exporting or importing from neighbors, curtailing your own exports, and engaging in things like demand response.
And there's no reason to think that the importing from neighbors is going to be unavailable.
That's right. And the government might suggest that that is during things like winter storms. But one thing that's true even in that context, and this is in JA 414, is that we don't all experience peak demand across the country at the same time. We don't all have outages at the same time. So it's perfectly common, even during the hardest winter storms or things like that, for importing to continue.
One very pointed question. The first issue was a surplus one.
Yes.
And that drew a fair amount of attention, particularly in the opening order. And is it your view that a surplus is kind of like a prophylaxis on top of a prophylaxis, such that no matter how much the surplus might dwindle, that can't be an emergency? That may well be right, but I'm just wondering if that's your perspective. So
yes,
can't be. That is at a layer of prophylaxis such that no matter what happens to that, we're not in emergency land.
that's right.
Okay.
And maybe as the surplus is lower, the increased risk would be one of needing to use these mitigation measures. It wouldn't be a huge risk that there will be actually blackouts on the ground.
That wouldn't be 202C territory.
Exactly.
Okay, thank you. Sure, my colleagues don't have additional questions at this time. Okay, we'll give you a little time for rebuttal. Thank you. Mr. Stander.
Morning, Your Honors, and may it please the court. Robert Stander here on behalf of the Department of Energy. The Secretary of Energy is not required to wait for a blackout to happen before invoking Section 202C of the Federal Power Act. In the Campbell order, the Secretary identified a shortage of electricity that called for immediate action. The circumstances he identified fit within the ordinary meaning of emergency as used in the statute. Within that boundary, Congress delegated to the Secretary sole discretion to determine how much risk is too much risk, how much of a shortage is too short. And the order must be affirmed so long as it's supported by substantial evidence, as it is here. If I may, I'll start by addressing the meaning of emergency, apply it to the circumstances here, and then turn to a key precedent of the Morant order, which directly refutes the petitioners, some of the petitioners' arguments here today, and that was ratified by Congress when it amended the statute in 2015. And I'll then turn to the petitioners' other main argument about usurping the role of long-term planners and show why that's wrong and should be rejected. To begin, there's a lot of back and forth in the briefs about the definition of emergency. And we can just dispense with that here today and start with the definition that petitioners cite from Webster's first. And Webster's second has the same definition, but is more timely. They define emergency as an unforeseen combination of circumstances that calls for immediate action. And then the statute adds specific circumstances that may call for immediate action, including a shortage of electricity. Now, that definition is fine as far as it goes, but it doesn't at all answer the question here, which is when the circumstances call for immediate action. How much risk of a blackout is too much risk? And Congress delegated that solely to the discretion of the Secretary. We apply that to the circumstances here. The Secretary identified a combination of four circumstances that called for immediate action. First is the imminent shutdown of the power plant.
So as a prefatory question, so this is all, I think, going to bolster the notion that there's a need for immediate action.
Correct.
So there's at least one statutory provision, and there's so many floating around, I can't remember the section number offhand, but it's adjacent to this one that uses the term immediate action in connection with emergency. And that's the succeeding provision. And just remind me what the words of that are, because it says it pairs emergency with immediate action.
Correct.
And then you have an argument in your brief, I think, that the negative pregnant of that is that because this provision, 202C, doesn't pair emergency with immediate action, then an emergency for 202C purposes doesn't actually require immediate action.
So we make that argument in our brief, Your Honor. We have the need for immediate action here, so I think that's sort of beside the point. But I think our overarching point is—
Okay, so you're not relying on that then. You're willing to accept that an emergency in fact is something that in fact requires immediate action.
The emergency here required immediate action. So within the scope of this case, we're fine with that definition.
But your assertion of authority actually is that something can constitute emergency for 202C purposes, even if it doesn't require immediate action.
I'm not making that argument here today. What I am arguing is that this provision.
But was that, I just want to understand, I'm not trying to be difficult. But I thought that was the takeaway from the brief, is that.
So the takeaway that I'd like to leave you with is 202C does not require intensifiers. It doesn't say last resort. It doesn't say absolutely we mean it only if absolutely necessary right now. It doesn't have all these added intensifiers. All these imminent, all these things that are in there. That's our argument today. Is it's just emergency, and here's what an emergency is: an unforeseen combination of circumstances that calls for immediate action. That's our point.
That's your understanding of an emergency.
Correct.
It does call for immediate action, actually.
So with this explanation, if I can explain the immediate action that was required here and that was required in the Morant order, I think it'll help clarify. So the circumstances here, the imminent shutdown of the power plant, an elevated risk of a blackout, according to NERC, the standard setting entity for North American grid reliability. And third, an unexpected surge in demand from energy hungry data centers. And then fourth, the shutdown of the plant required imminent action, immediate action, because the shutdown was to be permanent. And so once it's shut down, it's not available in times of peak demand, like during a heat wave or a wind drought or a severe storm.
I'm sorry, I was looking for the statutory language. Imminent shutdown of Campbell, the data centers increased demand, and your two others were?
An elevated risk of a blackout. According to NERC, the standard setting entity says there's an elevated risk of a blackout. And then fourth, the need for immediate action is because once the plant shuts down, it was to be permanent and you can't bring it back to serve in times of peak demand.
That's separate from imminent shutdown of Campbell. It's the difficulty of reversing that if you allow it to happen.
Correct. Right now, it was shut down May 31st. It was scheduled shut down. If we don't act now, this is permanent, it's done, and it's not going to be there. Now,
this is a more record and evidentiary question, or also definitional, but the order defines the emergency here as an anticipated shortfall in August of 2025. What is the department's view of what, in a factual sense on the ground, the current emergency is?
well, the emergency identified in this order, I just want to be clear, the only thing before the court today is this order. And so, in fact, we asked to have this order and a second order consolidated so that the entire record would be before the court. The petitioners objected to that, and the court denied that. So I think what we're talking about here today is just one order, and the combination of circumstances that was identified was a shortage of electricity. And the shortage of electricity required immediate action for those four combination of circumstances I just identified. So that's what this order is about. And
I don't understand that response, because if all we're reviewing is the initial order, which identified an emergency based on the events that were projected to happen in August 2025, why are we here? Because that's come and gone. The reason that we're still here, and I guess that this isn't moot, is because it's capable of repetition and could evade review. Therefore, why don't we look at what the purported emergency is now? Because it appears to be repeating. I mean, I don't understand what basis you think there is for us to ignore the facts as they exist right now, or the justifications that have been given to continue the emergency.
so, Your Honor, I'm happy to discuss that series of issues, as long as we're clear that the order under review here is the Campbell one order. The answer to the question, the current, just to talk about the current order, is a continuing shortage of electricity. Right, the continuing shortage of electricity, and to look at sort of some of the record support for that. It's hard to even talk about record support because we're talking about a record that's tied to order one, not a record that's tied to anything else. But the statements that are in the record from MISO, for example, two vice presidents of MISO, we have testimony in the record walking through the shortage, the issues with the grid. They say things like, so this is Todd Ramey, vice president of MISO, says changes in the grid, shifting generation from reliable thermal energy to unreliable wind and solar, and then, quote, unexpected demand for energy-hungry data centers. He says these changes pose a host of complex and urgent challenges to electric system reliability. That's testimony from May 2025. He says to maintain system reliability, we must respond to the unprecedented change. That's at JA 721. There's also testimony from Jennifer Curran, another vice president of MISO. So it's these sorts of statements that talk about ongoing grid reliability problems. And the response to that is to keep power plants, major power source, online. And that's a discretionary judgment call for the secretary that Congress delegated to the secretary in 202C. So that's, to answer the question about what's going on now, that's the answer to that. But just to take us back to the Campbell 1 order.
But aren't we supposed to, in construing 202C, to look at what I guess is considered 202A? And I hate referring to things by these shorthands when that's not what's in the U.S. Code. But I think the U.S. Code provision we're talking about is 16 U.S.C. 824A, subparagraph C. But if we jump up to subparagraph A, there Congress says, for the purpose of assuring an abundant supply of electric energy throughout the U.S., et cetera, the commission is empowered to divide the country into these regional districts, and then that's how you get MISO, and that's how this planning is all supposed to happen. So what are we supposed to do with that?
Well, Your Honor, this 202C order is clearly not doing the type of long-term planning that petitioners suggest when they point to this provision. Because this provision authorizes FERC to divide the country into regional districts. The secretary is not using 202C to divide the country into regional districts here. And he's not using 202C to create nationwide reliability standards.
I'm not saying that the secretary is doing what's in 824AA or 202A. I'm saying is that 202A is how Congress said long-term planning is supposed to be done. And the petitioners are saying that's why you don't use 202C to do long-term planning, and that's what's happening here.
Well, Your Honor, two responses to the long-term planning argument. I mean, the first is that long-term planning and 202C orders are not the hermetically sealed categories that petitioners would have you believe. Every time there's a 202C order, at least often when there's 202C orders, it will in some way interfere with or override the prior decisions of long-term planners.
But that's a different point from saying that 202C order can be used to respond to, I think as your brief argued, to alleviate longer-term shortages of electric energy, even if an acute shortfall or blackout might not materialize until much later. So that goes back to the series of questions at the beginning of Michigan's counsel's argument, which is if it's the kind of anticipated shortfall, even assuming there is an anticipated, that long-term planning has not yet woken up to a long-term risk, what's your response to the notion that, well, but it could, and the Department of Energy, including through FERC, has tools consistent with the state's primacy and the regional organization's primacy in long-term planning to go there to affect it rather than kind of diving in a unilateral way that doesn't take the systemic interests into account?
Well, Your Honor, if I could answer that question by responding, by discussing briefly the Morant order from 2005.
Right.
And look at the text of the statute and then talk about what's going on with the order at issue here from May to August last year. And then talk about the order, what went on during Winter Storm Fern in January. So taking those in order, the Morant order from 2005, it is squarely on point with some of the issues we've been talking about the need for immediate action now, but risk going on into the future. So in Morant, the Potomac River Generating Station was one of 3 power sources for Washington, D.C. The other 2 were 2 major transmission lines that connected D.C. to the grid. And the emergency arose when Virginia regulators ordered the power plant to shut down for violating air quality standards. Shutting down the plant would have elevated the risk of a blackout, but a blackout would only have happened if both other transmission lines failed at the same time. The Secretary invoked 202C, ordered the plant to remain open. In that circumstance, the only thing that was imminent was the shutdown of the power plant. There was no suggestion of an imminent risk of a blackout. There was no suggestion of a high probability of a blackout. And the Secretary acknowledged that in the order itself. He said, quote, "I recognize that the simultaneous failure or outage of both transmission lines is not a high probability." And then he said, "But there certainly is nothing in the statute that requires me to wait until a blackout actually has occurred and lives are put in jeopardy before invoking 202C." That's page 8 of the Morant order, and the source for that is in our brief at page 39, note 23. So Morant directly refutes this argument that there must be an imminent blackout, that there must be a high probability of a blackout. Instead, the imminent shutdown of a power plant coupled with an elevated risk is sufficient, and it's up to the Secretary, sole discretion of the Secretary, to decide how much risk is too much
But
risk.
is that a situation in which even if there wasn't a high probability of a blackout in the very near future, there was still, some not immaterial possibility of a blackout? And that is such a dramatic scenario that got to do something right now to make sure we stamp out that level of risk. It doesn't rise to the level of probable, but it's at the level of not something we can disregard, and it's too immediately pressing.
So 2 responses to that. I don't think there's, the Morant order didn't say anything didn't have any quantification of a risk. It's just that it's not a high probability, but it's good enough. Just the statute delegates this discretion to the judgment of the Secretary. And here we have NERC, the standard setting entity, saying there's an elevated risk of a blackout in the region at this time. And so that's a record question. And the record, all of petitioners' responses to that, they don't negate the fact that NERC says there's an elevated risk of a blackout.
But they do put it in context. Their position is that NERC routinely designates areas as elevated risk without those areas ever experiencing blackouts. It's not useful for actually predicting whether there's an imminent electricity shortage. It's a much more nuanced signal. What's your response to that?
Well, it's pretty difficult for environmental petitioners to stand up here and say, we know best, to say, substitute their judgment for the judgment of the Secretary and NERC.
Putting NERC's judgment in context and saying, we do understand what it means historically and how and whether any kinds of emergencies have either arisen or the Department of Energy has ever thought it was incumbent on it to respond to them.
So again, the statute delegates discretion to the Secretary to decide how much risk is too much risk. And as far as the NERC report, it very clearly says that there's an elevated risk of a blackout at peak demand. And then it even says, that Section 202C orders may be necessary. That's in the recommendations in that report. It says
What may be necessary?
202C orders. That's JA 110. Then fast forward for other evidence, just fast forward while we're talking about future orders to January of this year in Winter Storm Fern. So at that time, MISO issued an emergency alert and ordered maximum generation. During that event, the Campbell plant generated enough power to power 600,000 homes for all 16 days of that severe cold weather event. And that was at a time when all other power sources had already been ordered at maximum generation. This affected real people with real lives who use power for everything from medical treatments like dialysis to getting their kids a place to sleep. And so in very real world terms, these orders, in fact, offered power when it may not have been available. And for evidence of that, we point to the declaration of Tim Coker that we included as an addendum to our brief. That's page 17 of the addendum. He talks about the Campbell plant's generation at paragraphs 8 to 10 of that declaration. So, I think that goes through, I guess the last point that I was going to say is the statute, Judge Pillard, that the statute doesn't say the secretary may issue orders so long as they don't interfere whatsoever with long-term planning. In fact, it suggests quite the opposite, because subsection B, and this is 824A B, says the secretary may issue orders upon application from a state or from any person. And so that suggests when long-term planners want to apply, you go to 202B. But 202C doesn't say that it requires an application. In fact, it says the opposite, with or without application. And with or without notice, hearing, or report. So it expressly contemplates or strongly contemplates that these orders will be used to, in fact, override the decisions of long-term planners. The regulations say the same thing. The definition of emergency in the applicable regulation says extended periods of insufficient power supply as a result of inadequate planning can constitute an emergency. That's at 10 CFR 205.371.
Can I ask this question? So, and I think this brings into play the backdrop of the executive orders that are, or at least the determinations about coal power that are kind of in the air here. The first line of your brief is the United States is facing a national energy emergency. And does that mean, and it's a 202C case, so I assume you mean emergency in the 202C sense. So does that mean that right now, throughout the nation, any plant that wants to reduce its operations or shut down, 202C authority is in play?
No, Your Honor, that's not what we meant by including that in our brief. That's not our position. In this case, we're talking about a single order.
Why not? Why isn't that your position? Because why isn't a national energy emergency an emergency for 202C purposes? Because I think it would help me to understand what the distinction is.
Thank you. It's evidence of this emergency. So in another case, on another region, another state, it surely could be evidence of an emergency in that context. But what I mean is, in this case, we're just talking about a single order, and we think it supports it's evidence and it supports the shortage in this case.
And what is it? It's, again, just to help me understand the categories you're drawing. What is it about this case that you would distill to say it's over and above the national energy emergency that currently exists everywhere?
I'll give you, Your Honor, a combination of the four circumstances I mentioned before. So
okay, it's those four. Got it.
Correct. Yeah. Right. And NERC's, so a key piece of record support is NERC's summer 2025 reliability assessment that says that the Midwest region was an elevated risk of a blackout. And then that's, for the 3 months of this order, that's a key piece of support. And then you add the testimony from MISO's vice presidents talking about some of the broader problems, the reliability problems with the grid, and the other evidence that we've submitted in the record. That's all what supports it.
Okay.
So what is the line that I'm not sure that you have one, but the discretion of the secretary and the ability to foresee a potential shortfall, is it limited to the prediction of a blackout, or like what's the limiting factor in your reading? I know you say we're only reviewing this, but of course we're always, thinking about the precedent that we set. So offer us some limiting factors so that this isn't just carte blanche for a very interested energy secretary to skydive into anywhere in the country.
Yes, Your Honor. I think that a key limiting principle is that any order must be supported by substantial evidence commensurate with the scope of the order. So, for example, Suppose, I can imagine a winter storm, let's say some wild winter storm that covered the entire country from Texas to Maine in 3 feet of snow. And that had a severe, cold front afterwards. That kind of record evidence would support some broader order, perhaps. And so that's a key limiting principle: is what is the record evidence that is commensurate with the scope of the order. Here we have just a very narrow order that's focused on one power plant in one region, and it's supported by concrete evidence about an elevated risk of a blackout in this circumstance. So I think that's a key limiting principle. And I know it's difficult because the statute is open-ended. Congress did that on purpose. Congress reviewed this in detail in response to the Morant emergency in 2015. The Morant order is all over the legislative history of those amendments. It's referred to 100 times in one of the hearings. And Congress responded. So the particular problem Congress responded to was, in Morant, Virginia regulators had fined the plant for operating under the 202C order. So Congress responded, analyzed affirmatively looked at 202C and added the immunity provision in subsection C3, so that power plants are now immune from environmental regulations when they're operating under an order. Congress also added the 90-day limit and said each order needs to be for 90 days. You can renew it for unlimited periods, but then you need to consult with relevant agencies. So Congress thought about this. Congress thought hard and long about this and left the statute the way it is. Didn't add intensifier language. Didn't say only in these narrow circumstances. It left it open because Congress knows can't foresee all the circumstances that might happen. And so that's it has to be the end of I think, the sort of limiting principle we have.
Anything further? That's it for limiting principles. It seems to me that in your 4 factors, imminent shutdown of Campbell, difficulty to reverse that if the last minute one wishes one had the Campbell capacity online, data centers placing new and unprecedented demands on the grid, and then the elevated risk according to NERC. And it seems like if you take out the elevated risk according to NERC, that you don't have a basis for 202C. Do you disagree?
Well, I think in this order, the NERC report is a key piece of evidence.
It is. I read it that way too, from your position, that you can't just say, there's a lot of data centers coming and some coal plant is shutting down. The long-term planning has done some addressing to replace the coal plant. And data centers is putting demands everywhere. So
I think that's right, Your Honor. If I might all of petitioners' responses to that summer reliability report fail. They have 3 main responses. Their first, and they reiterated it here today, was to say it's no big deal. Trust us, there won't be a heat wave, there won't be a wind drought, nothing bad is going to happen. But that's for the secretary to determine, not for environmental petitioners to stand up and say, we know better, right? So I think—
For states?
It's for the secretary under section 202C to determine.
So they say one response, no big deal. Second response.
The second response is that both Michigan and MISO approved the shutdown of the Campbell plant back in April of 2022 or spring of 2022, right? That's of course not relevant because we're talking about 2025 conditions. And it's been between, that decision to shut down the plant was before all of this, before the surge in demand from data centers, before the 2025 report. All right. And their third, Michigan, but not the environmental petitioners, relies on a post hoc document, a July Department of Energy, it's July 2025 Department of Energy Resource Adequacy report. That report was decided after the Campbell order was issued in May, and it doesn't at all support Michigan. It compellingly supports the secretary and the department. It uses 2 models. So first of all, it's not in the record. It's in Michigan's addendum. It uses 2 models that are relevant here. One is called the current system model. Michigan thinks it supports them. It doesn't, because that model only uses data up to 2024. So the 2025 data isn't included. It's entirely irrelevant. Relatedly, that NERC 2025 summer reliability report talks about a surge in demand between 2024 and 2025 This is at JA 107 and again at 109. What they say is between those 2 years, 2024 and 2025, the increase in demand year over year was more than double. So there's a surge in demand year over year. The 2024 data is completely irrelevant. The second model in that July 2025 report, again, it's Michigan Addendum, is called the status quo model, or the plant closures model. That's the same thing. And it looks forward to 2030. And it says, if all the plants that have announced closure, they all close down, and we have continued demand like we're experiencing, what will happen? And it shows system-wide grid failure by 2030. So going forward, it's catastrophic, and it's completely irrelevant to the 2025 conditions that we're talking about here. So those are their three responses to the NERC 2025 Summer Reliability Report, and they all fail. If there are no further questions, I'll submit. Thank you.
Thank you, counsel. Mr. Schauf.
Thank you, Your Honor. Zach Shaw for Intervenors Consumers Energy Company, the Campbell plant's majority owner. We're here for a limited purpose, so I'm going to try to be quick. We worked closely with regulators and stakeholders to protect our customers while complying with legal obligations. When we agreed to retire the plant in 2022, we vetted our plan with the Michigan Public Service Commission and MISO. Then when the Department of Energy judged that Campbell was necessary because MISO as a whole faced a shortage, we worked hard to bring the plant back from the brink of retirement. Our limited purpose here is really just to ensure that nothing in this case undermines our ability to recover the roughly $43 million in net costs we incurred under this order. And we're seeking to recover those costs via the other track of Section 202C's two-track scheme, which vests emergency authority in DOE and then cost recovery issues in FERC. And the reason why I think it can be quick here is that on the issues where we've taken a position, which are pretty narrow, the briefing has converged in a helpful way. So first, everybody agrees that cost recovery is for FERC and belongs in appeals from FERC orders, not in this appeal from DOE's order. And second, on mootness, both DOE and the petitioners agree that the capable of repetition but evading review exception straightforwardly applies. These orders run 90 days. The FPA's mandatory rehearing period consumes 30 of those before a petition in this court can even be filed. And we already have the same basic dispute recurring in petitions that have sort of piled up before this court. I think the court can say that, make no new law. Maybe one piece to add, Judge Wilkins, in response to your colloquy with the government about sort of, the longer term concerns in, the subsequent orders versus the May 2025 order. If you look at page 42 of the rehearing order in this case, it really squarely tees up the dispute about using Section 202C to address, issues in the grid over the course of the next several years. So, that's in this case, and it's in the subsequent cases that have come before this court. Our one request really is this: whatever ground the court selects and whatever you say about mootness, we'd urge you not to suggest that vacature here would somehow entitle petitioners to refunds. We've briefed in part 3 of our brief the stronger proposition that we don't think those are legally available, even if the order here is set aside. But we really think the proper approach for this court, given the Federal Power Act's division of authority, if you say anything about refunds at all, which we don't think is necessary, is just to say those disputes are for FERC to address in the first instance. And
it sounds like you're about to finish, and
I am.
It's basically a site check question, which is just to make sure I have the page right. That you pointed to 42 of the rehearing order because it's the juxtaposition between the current order, the order that's under review, and the subsequent orders.
Yeah, paragraph 42 of the rehearing order,
I didn't think it had 42,
which tees up these sort of medium-term resource adequacy concerns.
I just wanted to make sure we had the right list. Okay.
Yeah.
Thank you, counsel. Mr. Shagnon, we'll give you the 3 minutes for rebuttal.
Thank you, Your Honor. So I have a few points I'll try to hit within that 3 minutes to just clear a few things up. So the first thing I want to say overall is that you heard the government effectively adopting the approach to emergency that we discussed in our earlier portions. So I just want to make that clear. The second is I'm not standing up here saying that as an environmental lawyer's preference for risk is what should govern. I'm saying this court should defer to what MISO and NERC and the states have said about this very problem. They've repeatedly distorted what that record actually shows. And if you look at a few pieces of that, you can see that there was no resource adequacy problem. So if you look at JA 69, that's where the MISO results say there demonstrated resource adequacy. If you look at the Ramey testimony he mentioned, both at 726 and 739, that MISO executive made clear that there's no resource adequacy problem in the near term or in the future. And resource adequacy is just the idea that there will be enough power to deliver to consumers. He makes a lot of references to the NERC assessment. He suggests our view is that we are denying that hot weather will occur and other things like that, or there won't be storms. That's absolutely not true. NERC itself accounts for the existence of warm weather and storms. And if you look at 3 pages within the NERC assessment, they show pretty clearly that the blackouts that the government suggests are going to happen are not. So on JA 118, I mentioned this in my opening remarks, they make clear that the real risk here, the elevated risk here is that reserves, which is again that surplus, might be lower. But the upshot of that is in blackouts, it's that these mitigating measures that are well in place that DOE knows about because they're in MISO's tariff and NERC has required some of them will be used, not that blackouts will occur. He mentions this piece of the NERC report that says that 202C orders might need to be used. He omitted the fact in extreme weather conditions, and our position here isn't that anything needs to change about 202C, and it still can be used in a short-term way. That's exactly what happened 1 month after this initial order, where Duke Carolinas asked for a 42-hour order to deal with a summer heat wave. And the last point is that if you look at JA, I believe it's 114, there's a suggestion that kind of embraces this surplus on top of surplus idea. They say the risk might be higher if they had stuck exactly to the reference margin, but they went above and beyond that. They got more. So the last point I'll try to make is about the Morant case, which I think my friend on the other side suggests dramatically supports his position. But there's 2 pieces of that that I'd like to clarify. One is that up top in the order on page 2, it makes clear that they were facing an immediate reliability concern. And the reason that it was an imminent reliability concern in the sense that we've been talking about is when you're talking about transmission lines, there's only 2. If either of those go down, the utility would have no other way of solving the problem other than running the Morant plant. And all sorts of other circumstances, there would be other solutions along the lines of these mitigation measures or running some other plant.
Did you say if either goes down?
That's right. There was 2, and there had been recent history where both had gone down, or there's the possibility when you have transmission lines that you want to take one down to do maintenance and other things like that. So it was a very pressing need there. And one other thing he overlooks is that on page 9 of that order, the department makes exactly our point, which is, look, we don't want you to take this, DC, as an invitation to not do better planning going forward. We expect you're going to really go all out on building a better transmission line because this is not our lane and we don't want to be in it. And that's all the position we're adopting here in this case, and we think it appropriately is followed. And the very last point I'll say, if I may, is on the idea of my friend said his real concern here is that you can't bring the Campbell plant back, but he also says we're not trying here to engage in resource adequacy planning or generation planning ourselves, and those are fundamentally in tension. MISO and the states all looked at whether Campbell was needed to address problems going forward. They said no, and the reason they said no is because it's a harmful, unreliable plant. The department has a different view now, but it has nothing to do with whether it's needed.
Can I ask one question about the NERC report?
Yes.
And the point on JA 110 about the forecasting the possibility that 202C authority may be
Yes.
needed. So I take your point that it says specifically contemplates the exercise of 202C
That's right.
authority, and it says 202C may be needed to ensure that sufficient generation is available during extreme weather conditions.
That's right.
Are you reading that to mean, because you're emphasizing extreme weather conditions, are you saying that it's only contemplating the use of 202C when there's in fact extreme weather and we're going to react in real time to extreme weather? Or is it saying that 202C may be necessary to make sure that if there is extreme weather, there's going to be sufficient energy available then? Because the latter would indicate that it would at least leave open the possibility that you may need to use 202C now because you never know when there's going to be extreme weather, as opposed to let's wait until there's the extreme weather event and then exercise 202C on the spur of the moment then. Or am I missing the distinction you're drawing?
So I'm reading it the first way, which is 202C still will be this last resort backstop if we look at the weather report and see next week it's going to be 105 degrees. And that's exactly how it was used, again, a month after this order, in this Duke Carolinas instance, where
There it was used to say, fill me in on that you can run without environmental compliance. Like
That's right.
explain that, why that matters and why, like, you couldn't bring Campbell back in a dirty mode and just at the last minute, or?
That's right. And Duke Carolinas is not within the MISO footprint.
Yeah, no, I know that.
But what it shows is that was a case where Duke Carolinas saw 1,500 megawatt of generation was currently on outage, and it also confronted, there's a heat wave next week. And the response was, which is often a typical response in these circumstances, we're going to allow you to temporarily exceed your permit requirements to allow your existing generation to squeeze out a little more juice. Recognize that may conflict with environmental regulations, but we'll allow it for 42 hours. And that's typically how 202C has been used. And it's, my friend mentioned that this balance was struck in amending the statute in 2013, where, and that's an important reason why we should channel all of these exercises of planning outside of the 202C context, because one very important thing that you steer into in that when you use 202C pretty often is a conflict with environmental law, whereas other pathways will allow you to continue to comply with environmental law, use imports or things like that without creating this legal conflict.
Make sure my colleagues don't have additional questions.
Yeah.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Thank you.
Thank you. I'll see you.
Case number 25-7097, Yukos Capital Limited, formerly known as Yukos Capital, SARL, versus Russian Federation appellant. Mr. Marks for the appellant and Mr. Rosen for the appellee.
Russian visitation under here. Russian.
We just might have a second to get organized, Your Honor. When I'm done, I'd like to introduce the attorneys here who've never been in this court. Their names are long, so after I use up my time.
If you're ready to proceed, Mr. Marks, please proceed.
Yes, Your Honor. My name is Bruce Marks. I'm counsel for the Russian Federation, and I'd like to reserve 2 minutes for rebuttal. Wholly held whether arbitration is inconsistent with Russian law under ECT Article 45(1) is jurisdictional. The district court accepted Russia's position that Article 45(1) applies article by article, but rejected its position that arbitration is inconsistent with Russian law with literally no analysis. The entire Russian law opinion in a $5 billion case is 4 sentences. The only Russian law cited in that opinion was Article APC, Arbitrage Procedural Code, Article 198.3, which for some reason the court pulled from the internet and didn't use the certified translation submitted by the parties. The court did not discuss Russia's constitution, other relevant statutes, Russia's expert evidence, legislative history, or a single Russian Supreme Court, Russian Arbitrage Supreme Court, or Russian Constitutional Court case that we submitted. And each of these courts are apex courts whose interpretation of Russian law would be binding on this court under the Hilton animal science doctrine. And only one of those cases was contested by the other side. Russia's evidence of Russian law establishes arbitration is not just inconsistent with, but precluded by Russian law under the unratified ECT. This requires reversal and remand, and this court has remanded in Eschel and other cases on issues of foreign law in order for the district court to properly analyze both sides' evidence unless this court wishes to decide Russian law in the first instance. And I'm prepared for that, and I will begin my argument on that. Our briefing established Russian law precludes arbitration of public law expropriation claims unless authorized by a statute. This is established by Constitution Articles 46.2 and 47.1. They're in the addendum, and they require these claims, public law claims, to be filed in Russian courts, quote, whose jurisdiction is determined by statute. APC Article 198.3, which is a statute, mandates jurisdiction for these claims in the arbitrage courts, unless jurisdiction of other courts is provided by statutes. And the Supreme Arbitrage Court, an apex court, held twice in 2014 that public law disputes may not be arbitrated unless authorized by statute, and actually vacated 2 awards. This is at JA 2409 at sequence and JA 2399 at sequence. Further, the Supreme Court plenum held in 1995 and 2003 that under Russian Constitution Article 15.4, international treaties to provide, quote, rules other than those envisioned by law, end quote, must be ratified, quote, in the form of a federal statute. There's 2, resolution number 8 and also resolution number 5, JA 2424 and JA 2426. In 2009, the Russian Supreme Court reversed application of an unratified treaty which contradicted a statute in the China border case. That's at JA 2428. This law, which the district court did not even consider, clearly established that arbitration pursuant to the unratified ECT is not just inconsistent with Russian law, but precluded by it. So this court clearly has to reverse the district court's decision, essentially relying on nothing, and either remand, or I'm happy then to argue the relevant Russian law first. I'm sorry.
Your primary position is that we just simply remand this for the district court to consider either issue preclusion or determining the Russian law itself.
Your Honor, our absolute position in the brief, and as most recently by the Rule J letters, is that issue preclusion should be remanded for the same reasons that this court did in Hulley. And there was a recent decision by this court, I believe, related to India, where it also remanded issue preclusion. We know that GOJ has now weighed in with their opinion. We're kind of brief it this week, right? Judge Howe in the Hulley case is diligently at work, has requested the party, has dug in with what this court directed in the appeal order parties are in the process of briefing it. And if this case is remanded, we would expect Judge Nichols to do the same. And yes, in your honor, there's one issue there's a number of issues that I can attack Resolution 8P. That's the only thing that they hold their hat on that. We don't think that their interpretation is wrong, because we know that there's never been a case in Russia.
Wait, you don't think their interpretation is?
Their interpretation is wrong.
You do think it's.
Yes.
You think it's wrong. Got it. Okay.
Yes. Yes, we do. Very wrong for a lot of reasons. On the issue of remand, Judge Wilkins, I think the issue of foreign law cries for remand. I know each of the members of this panel would love to deal with Russian law in the first instance, but the fact of the matter is, there's a Second Circuit case, Bugliotti, where it talks about how even though much of Russian law is a 44.1 issue, nonetheless, district courts will often use fact-based procedures to hold hearings, to look at the expert testimony. There's a lot of expert testimony in this case, as you all saw. We have Professor Optinoma's reports, two of them, the second and third. They have Professor Stefan. Reading Russian law cases is not the same as, ye olde England. So I can see reasons why this court would do that. Let me give one reason, however, it would be that this court could easily decide the Russian law issues. Otherwise, I'm happy to argue.
And will this reason treat with 8P?
Yes.
Okay.
Indeed it does, Your Honor. Indeed it does, and that's 2020 clarification. And we believe that Resolution 8P was misinterpreted, obviously, by Yukos Capital and also by, some of the other courts that heard it. Resolution 8P concerned a statute on a tariff. A tariff is set by it concerned a case on a tariff, not a statute. Tariffs are not set by statute, so is set by the government. All Resolution 8P decided was because that treaty affected the rights of people, right, by increasing the tariffs. It was similar to a ratified treaty. And because ratified treaties had to be published, because they have the same concept, you're entitled to know the law. They held by implication, that's the words in 8P, by implication, therefore, a treaty which applied provisionally had to be published as well. There was not even a statute at issue in 8P. And therefore, it never discussed whether an unratified treaty could overrule a statute. And of course, that would make no sense, because what reason would there be for the Russian Constitution to require ratification? Article 15.4, why would Russia have two statutes? The USSR, FLIT, Foreign Law of Investment Treaties, which we believe governed, or the 1995 FLIT, which both require ratification for treaties which overrule statutes. That's the role of their legislature. They have the same concept of separation of powers, right, that we have in this country. The 2020 clarification, Your Honor, dealt with the fact that there were courts outside of Russia which misinterpreted 8P. It's straightforward. When you look at the 20 clarification, one issue was the tribunal in this case, 2-1, misinterpreted 8P, and the other were the Dutch courts, which are not at issue here. We're dealing with Yukos Capital, the Swiss case. In the Russian Constitutional Court, pursuant to its procedures, was allowed to clarify 8P. And what the Russian Constitution Court in the 2020 clarification did at the request of the government, and also the participant in the underlying 2020 clarification.
That's the Christmas opinion?
Well, that wasn't Christmas in Russia, but yes, Your Honor. And listen, we have, that's what the other side, maybe without great respect, calls the 2020 clarification.
Sorry, I didn't realize that.
Right. Yeah. No.
Okay, but we're talking about the same opinion that is clarifying 8P.
Yes. Yes, it is. And there was some imprecise language in 8P. And again, that decision did not deal with a statute. So that decision
we would have to apply the normally existing standards about whether to give effect to the Christmas decision, right? And there's an argument that's being made on the other side that if you apply the normal standards to decide whether you give effect to a decision like that, they point in the other direction, that you wouldn't give effect to it. What your response to that is?
And I'm happy to respond to it as long as I can call it the 2020 clarification.
Yeah.
The answer is we're familiar with Hilton. We're familiar with animal science. And they make two type of attacks on the 2020 clarification, or at least really one. They attack the integrity of the judges in the constitutional court who made that decision. Our view is that that type of attack on those judges in this court it doesn't belong any more than unfortunately, the attacks on some of the judges in this courthouse. They attack their impartiality. They claim that the decision was politically influenced. Okay. I'm sorry, Judge.
Just specifically, the claim is not necessarily directly on the judges, but that at the request of the Putin administration, the legislature stripped the justices of their tenure protections, which in our system is meant to make you more responsive to the political wishes of the leader if you don't have tenure protection.
Your Honor, that's not what they said isn't exactly correct. There were amendments to the statute that authorizes the constitutional court. They got it partly wrong. Many of these amendments were in place for a long time. There were some changes in the way that the tenure system worked. However, what was never changed is that in order to remove a judge from the constitutional court, that removal has to be approved by the legislature. So it's no different here than in this country that if you're going to impeach a judge, that the Senate, okay, the legislature would have to rule on it. So the judges, Your Honor, were fully protected. And again, Your Honor, they did make I do think there's an attack on the integrity because they did say they were subject to political influence. Okay. Your Honor, so what they're doing in a way, I think, is they're attacking the integrity of the Russian courts. Some of that, in my view, and it's in our brief, is fact-based. If you're attacking the integrity of a court system, if you're attacking its adequacy, we have a lot of cases, in the area of forum non-convenes. And we know that this court, in reviewing what the district court did in terms of the adequacy of a foreign system in the air crash over South India case, recognized that review is subject to an abuse of discretion standard. So what I'm suggesting, Judge Wilkins, if this court is going to give credence, and we don't think that their allegations go to the level of giving credence, but if this court, and again, the district court never decided it, so you're absolutely right. Even if you don't give credence to it, I suppose that this court could, and I submit should remand.
Don't give credence to which?
Their allegations of political influence. They've made those allegations.
They also point to something about the request for reconsideration, whether it's secret or not secret. Do you have a response to that? Do you know what I'm referring to?
I do, Your Honor. And the reality, our judicial systems are not inadequate simply because they're different. There's a lot in the Russian Constitutional Court. Those proceedings, the proceedings are not public. Okay, I could tell you in this case. The district court's decision to deny our motion to dismiss was not public because he didn't have a hearing. So I don't think that it's uncommon in other judicial systems that hearings are not public. It was not ex parte, Judge. The parties that were notified of the case were obviously the Russian government that brought it, but also the original claimant in the tariff treaty case. Now, if Your Honor is going to say to me, well, he had no dog in the fight, I'm going to tell Your Honor that's correct. So in that way, I'm not suggesting that it was a fully adversarial proceeding. But sometimes that you have cases, where a court will clarify a decision and the other side isn't affected by it and the court goes ahead and does it. And that actually, Judge Pillard, happened in this case. For some reason, the district court ruled on an original objection to service because it was originally served on our embassy. The Russian Federation's position is the same as the United States position. You can't serve embassies. You have to serve the State Department, or you have, in our case, the Ministry of Foreign Affairs in Russia. They eventually served the Ministry of Foreign Affairs, and we withdrew our objection for reasons we don't on the record. For reasons I don't understand, the district court went ahead and ruled on that and said you could serve embassies.
I have one quick.
I went into a distraction. But my point is that sometimes things are not contested.
I have one quick question about the.
Sure,
the
sorry.
2020, and then we'll.
I know I've taken my
We'll
time.
give you a little bit of time for rebuttal.
Thank you, sir. Judge.
I have one quick question about the 2020, which is, am I right? And you may have covered this, but I missed it. My understanding is that there were amendments to the rules that by which the proceedings would have been more transparent and public, but then in advance of this one, it was changed so that they weren't. Is that not right, or is that?
It's partially right, Your Honor.
Yeah.
There were amendments so that there would not, so that going forward, there were not public hearings in the Constitution, in the Constitutional Court. In the past, the way that it worked is if there was a public hearing and then there was an effort to clarify that decision, the clarification process would be the same as the prior one. If there was a hearing, then the clarification process would be public. If there had been no original hearing, then it wouldn't be public. So that there was a half change, Your Honor. But let me just say this, and I'm going to finish, and I appreciate the extra time. Yukos Capital was never a party to the 2012 HP in the first place. It would have never had standing to participate in the clarification. And then my only point, Judge Wilkins, we would support remand in this case, but in particular, if there was concern about the adequacy of the Russian courts, we believe that that's clearly an issue for the district court to decide in its own discretion in the first instance. Thank you very much.
Sure, count. We'll give you a little time for rebuttal. Thank you, counsel.
Thank you.
Mr. Rosen.
Thank you, Your Honor. May it please the court. Matthew Rosen for FLE Yukos Capital. Russia had a full and fair opportunity to litigate its provisional application arguments in the Swiss Supreme Court, in the country that it agreed to as the seat of arbitration. The Swiss Supreme Court rejected all of Russia's arguments in a thoughtful, well-reasoned opinion. That decision is binding, and it's also correct.
Swiss law itself doesn't even recognize collateral estoppel, does it?
Well, when applying principles of collateral estoppel and comity to a foreign court system, we have to be very careful because court systems, the Hilton decision recognizes that comity applies to a wide range of legal systems. It talks about Russia, it talks about civil court systems, and the concepts do not necessarily apply identically, but there are ways in which the Swiss court system achieves finality, and it is that finality that is entitled to respect. My friend on the other side, in their briefs, in their third expert report, they acknowledge that having litigated this issue of provisional application before the Swiss Supreme Court in a set-aside proceeding, Russia could not contest provisional application as a basis to oppose enforcement. Now, they say that's because of procedural rules. It's not because of issue preclusion or res judicata. But at the end of the day, the Swiss system is achieving finality. And those same principles. So this court would be giving.
Even the way you just described it, it didn't even sound like you were relying on issue preclusion. Are you actually relying on the doctrine of issue preclusion? Or are you saying there's something that's kind of close to issue preclusion, given Judge Pillar's question about the actual effect of the Swiss resolution under the Swiss understanding itself?
So the way that I would look at it is that, and the U.S. brief looks at it this way as well. You apply U.S. principles of issue preclusion. And that makes sense because we're dealing with decisions of foreign courts, and it would be burdensome and contrary to the principles, the efficiencies achieved by issue preclusion to have to kind of go into each foreign court's law to figure out exactly, how their doctrines map onto ours. But we would not dispute that there is some role for foreign law to play when if a foreign court were to say, look, the nature of this decision was too tentative. We wouldn't follow it. It's not final. It could be relitigated in a similar type of proceeding. That would be an exception, perhaps, to the U.S. doctrine of issue preclusion. But we're relying on the U.S. doctrine of issue preclusion, and we're relying on the fact that this issue could not be relitigated in the Swiss court system in the same context.
Mm-hmm.
The U.S. brief makes clear that there's no barrier to applying issue preclusion in the context of an issue that arises in foreign sovereign immunity. And all of the requirements for issue preclusion and comity are met here. The Swiss court is a notoriously neutral court. The procedures here were completely regular. Russia agreed to Switzerland being the seat of arbitration, and they chose to submit this question to the Swiss Supreme Court.
In my view, the arbitration exception is really the first ground to consider. It's just more well trod by precedents of our court, and Russia relies on the 2020 decision to say that Russian law prohibits provisional application of a treaty for investor state arbitration. And your primary response is that 2020 decision is unreliable. But you also argue that it's irrelevant to assessing the existence of Russia's agreement to arbitrate at the time of Yukos's arbitration against Russia. Why is that the time period for these purposes when the arbitration took place?
So it's the time period both under international law and under the Foreign Sovereign Immunities Act. So international law is well established. We cite several well-settled authorities that recognize that if for purposes of international arbitration, you view the jurisdiction of the tribunal at the start of the arbitration. And that makes sense under the FSIA as well, because the FSIA doesn't say there has to be an agreement at the time of the court proceeding. It says that the award has to be issued pursuant to the appropriate type of agreement. And so if the agreement existed at the start of the arbitration and the arbitral tribunal relied on that existence of the agreement at that time in issuing the award, that's all you need for purposes of the FSA. I'll also point out that the issue preclusion argument resolves their reliance on the Constitutional Court. The Swiss court, if you look at the bottom of page 750 and the top of 751 of the appendix, addresses the merits of the 2020 Constitutional Court decision. And it said Russia has failed to establish that decision actually represents the law of Russia at the relevant time, as opposed to a revision of Russian law after the fact. But even if you want to reach it on the merits, I think the conclusion is the same. And it is not entirely based on the fact that this is a suspicious, procedurally irregular decision, although that is certainly true. But even without that, the Supreme Court has said in the analogous context of evaluating a state court's ruling on state law, that courts temper their deference to state court decisions on state law when there's a higher order norm that would be undermined by blind deference. And so in the state context, that's the US Constitution. In the elections context, in the contracts clause context, and in the takings clause context, there are circumstances where the federal Supreme Court, federal courts will second guess state courts on issues of state law, because if they didn't, states could easily defeat their constitutional obligations. And that is exactly the circumstance here.
That's by an analogy, by way of.
By analogy, but I think Russia concedes the analogy. They themselves invoke an analogy to state court. That's the analogy that's drawn in Elmendorf versus Taylor 200 years ago, animal science products more recently. So I think the analogy stands. And it also makes sense for purposes of the Energy Charter Treaty. The provisional application provision of the Energy Charter Treaty would be a nullity if all you needed as a foreign state, having provisionally agreed to apply a treaty, to have your court system after the fact, after you've already lost more than $55 billion of arbitral awards, come in and say, actually, this is contrary to our law. No country would ever be bound provisionally by the Energy Charter Treaty if you adopt the level of deference that Russia advocates. Further, even if you don't think the proceeding was corrupt, it does not meet the requirements for comity under Hilton, because the parties here didn't get to participate. There was, Russia acknowledges there was no adversary in the proceeding. An adversary who had no interest in the case was invited. The investors whose interests are at stake did not get to appear. you layer on top of that all
They weren't the only party whose interests were at stake. I mean, any number of parties going forward
Correct.
would be affected,
Well,
identifiable and not.
Well, I don't think it's true that parties would be affected going forward, and that's part of the reason that the decision is suspicious. Because by 2020, Russia had withdrawn from provisional applications.
2020 after, it's only where you have this kind of straddle. And is this the only case? Or I guess there's at least a finite universe of cases that were arbitrated before and then
Right.
arguably subject.
Yeah, and there's no real prospect of arbitrating ECT disputes after 2020 because Russia has been,
Aren't other cases in Yukos's category?
there's the Holy case.
Hully, right?
But the Holy case is what motivated the decision, right? Holy didn't participate either. And the timing makes it very clear that this was about getting out of the Holy Award and this award because Russia had just lost in the Dutch Court of Appeals.
And you're saying that's basically the universe of like cases.
I think there might be a third award, but they were certainly not issuing this opinion to clarify Russian law going forward. They were issuing this opinion and they specifically addressed the ECT, even though it had been they've been withdrawn from provisional application 11 years earlier. They specifically addressed the ECT because the conceded purpose of this decision was to get out of the Dutch court's decision. They told the Dutch court that. So there's really no dispute that you have a fox guarding the hen house here if you let the Russian court.
When you say conceded purpose, what exactly are you referring to?
Oh, I don't have the site handy, but it's in our brief. They told the Dutch, I believe it was the Dutch Supreme Court, that the reason they were seeking clarification of this decision was because they believed that the Dutch Court of Appeals had erred.
Mhm.
So it was precisely because they were in a proceeding to enforce a $50 billion arbitral award against them. They didn't like the outcome. So they decided that they would have their court reconsider the question. And if that's all you need to do to get out of an ECT award, you would never have really binding provisional application. And if I may, there's no basis for any of the reasoning in the Constitution.
I mean, you got to win on getting the resolution that you want from the court, right? I mean, it's not just that you open it up. You actually have to prevail in your interpretation.
Right. If you don't follow the Christmas decision, the 2020 decision, we still have to win on Russian law. I'm happy to walk through the authorities my friend on the other side cited. None of them provide any basis for their argument. I'll start with their premise that treaties that contradict or the treaties that require ratification cannot be applied provisionally. Well, no one disputes that the ECT is subject to ratification. It says that on its face. It also says it applies provisionally. These concepts are compatible, and the Russian Supreme Court recognized that in its 2014 decision 6P, where it held that a treaty that required ratification was subject to provisional application. It upheld provisional application for that treaty. So the fact that the treaty has to be ratified does not mean it can't be applied provisionally pending ratification. I'll point to Arbitrage Procedural Code 198.3, which they rely on to say that Russian law requires certain kind of public disputes to be litigated in a certain Russian court. But that provision is expressly subject to an exception. It says, unless another statute provides otherwise. And there is another statute here. That other statute is the 1999 investment treaty, or the foreign investment statute, that expressly provides that when a treaty provides for arbitration of investment disputes, then you can arbitrate those investment disputes. So there's no contradiction of Russian law in allowing for provisional application of a treaty that provides for arbitration. Further, even if there was a contradiction, Russian law provides that provisionally applied treaties supersede contradictory statutes. And for that, let me walk you through a couple different authorities that make that clear. We start with the Vienna Convention, which was codified as a statute in Russia even before its constitution was adopted.
Yeah, I think this part of your argument has been understood in other courts too.
Absolutely. Yeah. The Dutch Court of Appeals decision is crystal clear on this. The Swiss court decision recognizes that, well, all you have to do to get out of their authorities is just follow the analysis in those decisions. And
Let me make sure my colleagues don't have additional questions at this point. If you have a
Okay.
final point you want to wrap up with, that's fine, but otherwise,
no, if that's all your questions, I would ask the court to affirm the decision.
okay.
Thank you.
Thank you, counsel.
Your Honor.
Mark, we'll give you the 2 minutes that you asked for rebuttal.
Yes, number one, we believe issue preclusion should be remanded. I don't think there was a square answer on the Swiss issue, but we've already argued that. Number two, Your Honor, some of what he said about the 2020 clarification is just simply wrong. Okay, Russia withdrew from the ECT in 2009. Okay, it's a 20-year window. Okay, for investments that were made in Russia at that point. So until 2029, these type of claims can be made. And I would suggest to Your Honor, there's a real risk that they may be made in the future because of the dispute between Russia and Ukraine. This court has already dealt with some of those disputes, albeit under a bilateral investment treaty. With the 2020 clarification right at the beginning said that it was clarifying not because of the cases that had already been decided, but because of the cases that might be decided in the future. So that's number two. This is the analysis is one that would be decided under Hilton and animal science. The U.S. case in the U.S. Constitution and the states that is a completely different issue. The U.S. Constitution is not an issue. And in our case, this court would apply Hilton and animal science. Three. There was another point that he made, but my point is the 1990 fill. You can take a look at that. That's the foreign investment law. It doesn't. They said on page 34 or 35 in a footnote in their opposition brief, they said that statute's just a pass-through statute. It says that you can allow arbitration, but in order to allow arbitration, it has to be authorized by ratified either by a statute or treaty, which is ratified by a statute. Let me just conclude. They have not cited a single case in Russia which said that an unratified treaty could override a statute. They have not cited a single case in Russia that said that an unratified treaty could change the jurisdiction of courts. And here the arbitrage court 198.3 is exclusive jurisdiction unless a ratified treaty changes that. And they have not cited a single case where a provisionally applied treaty could override a statute in any context. I have cited two cases today where the Supreme Arbitrage Court actually vacated arbitration awards because they said that was contrary to Russian law. I want to thank the court for the generous time that you've given me. I have three attorneys here in my firm, Maria Grachiskina, Timur Zabuldian, and Polina Izmulevin, who are in this court for the first time today. All of them are American attorneys. They're originally from Russia, and we very much appreciate the opportunity that you've given to us to present ourselves today.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 25-5339, SGCI Holdings, 3 LLC, and Soyoung Kim, appellants versus Federal Communications Commission et al. Mr. Strawbridge for the appellants, Mr. Burnley for the appellees, Ms. Kaler for the appellants.
Morning, counsel. Mr. Strawbridge, please proceed when you're ready.
Thank you, and may it please the court. Patrick Strawbridge on behalf of the appellants, SGCI, and Mr. Kim, who is in the courtroom with us today. The decision below violated the cardinal rule of 12b6 motions, assuming the truth of the allegations as pled and drawing all inferences in the plaintiff's favor. To the contrary, the district court drew inferences in the defendant's favor, wrongly imported its incomplete assessment of the merits into its standing decision, and dismissed the private defendants on a deeply flawed application of the Noor-Pennington doctrine. In nearly 400 detailed paragraphs, the amended complaint describes unprecedented efforts by the defendants to obstruct and eventually pocket veto Sue Kim and Standard General's attempt to require TEGNA. The combined actions of the defendants forced Standard General to pay a breakup fee in excess of $130 million. It cost shareholders more than $1 billion of value. The amended complaint describes the FCC's admitted use of race, its departures from its standard timeline, its demands for information about other potential transferee that both its prior practice and federal statute forbade. The complaint describes Byron Allen's use of the FCC's racial diversity policies to advance his own business goals, his attempts to acquire TEGNA for himself, his suggestion to Mr. Kim that he could smooth things over with the FCC if he were made part of the deal, his connections to the objectors who pressed for delay at every turn, asserting arguments foreclosed by agency precedent inconsistent with the facts and shaded with racial overtones. And the complaint cites numerous contemporaneous observers, including former FCC personnel, Republican and Democratic politicians, a sitting U.S. senator, and NAACP officials who opined at the time that Mr. Kim was being unfairly treated, including because of his race. The decision below ignored many of these allegations and minimized others. Of course, no one wants to believe that a successful Korean-American entrepreneur would be the victim of racial discrimination in the 21st century. But the rules of pleading are the same for Mr. Kim as they are for all civil rights plaintiffs. This court should reverse the decision below and remand the case for further proceedings so Mr. Kim can have a chance at his day in court.
The district court ruled that to the extent that your complaint quoted from documents, that those documents were considered to be incorporated into the complaint without converting the motion to dismiss into a motion for summary judgment. And that's the way that the district court analyzed the motion to dismiss. And I don't see anywhere in your brief that you said that that way of proceeding was improper.
No, we don't have a problem with considering statements that are referenced in the complaint as part of the overall consideration of the motion to dismiss. We do have a problem with the interpretation and the selective consideration of facts that the district court engaged in when looking at some of those documents.
No, I think what the district court did was the district court said that to the extent that your complaint quoted something from a document, then that document was, and it was explicitly referenced, then that document was considered incorporated into the complaint. And then it was fair game for your friends on the other side and for the district court to look at the context of what was in the entire document as opposed to the selective quotation that was used in the complaint.
And I don't disagree with the procedural point. I think that standard rule is that documents quoted in a complaint are subject to at least being reviewed on their face. You don't necessarily have to credit the statements in those documents, and you certainly don't have to do what the district court did here, which is resolve all ambiguities in view of the defendant's claims, rather than assuming that the plaintiff's allegations are true and all inferences that the plaintiffs draw from that need to be credited at the 12b6 stage. And that's where we think the district court really went over the line, either ignoring many of the allegations or only or adopting the defendant's view of what the document said in light of.
It seems like part of what the district court did, and what's, I guess, part of the key part of the dispute here, is that to the extent that the agency expresses its reasoning for taking the action, for setting this for a hearing, We have those reasons. But what you want us to do is to take the allegations in your complaint as the real reasons for the agency's actions, right?
Well, yeah, pretext is very commonly asserted in all sorts of racial discrimination cases. And I think as this court has repeatedly recognized, racial discrimination defendants rarely provide clear stated or direct evidence of racial discrimination. There's a number of ways.
But I guess what I'm saying is that this is different than your normal case because you're using statements by people who might have been advocating something to the commission as evidence of the pretext, as opposed to statements or actions by the commission itself in a lot of instances.
In some cases, not exclusively, we do, and I do want to emphasize something that the district court basically gave no weight to, which is that we have an allegation that Mr. Kim actually met directly with some of the FCC personnel involved, raised complaints about the way that his race was being used against him and some of the comments that the objectors were making. And the response, as alleged in the complaint, is that's not what it meant. It didn't say that. It was to laugh off the concern and say, you should hear what they say about you in private. And I would just submit that if you had an employee in a Title VII case who presented that kind of fact after raising concerns about racial discrimination, most courts would have no problem at the 12B6 stage, at the pleading stage, assuming that that's an inference at least that racial discrimination might be countenanced by the government actor in this case. You also have, like we said, the FCC's admitted use of race as part of the FCC proceedings. We have the disparate treatment that we allege Byron Allen's deals have received, both with the objectors not participating, but the FCC approving those under normal timelines, not imposing the kind of extraordinary delays that you have here. We obviously have pled a lot of facts about meetings that the FCC commissioners had with various people, ties that they had to Byron Allen and back to Dish. There is a litany of evidence here. I would say normally in a 12B6 posture, when you're pleading a racial discrimination case, you need some factual allegations that at least provide some breadcrumbs that if you're given the chance to explore in discovery, they might lead you to a cognizable claim. Here we have at least half a loaf, if not a full loaf, the entire story. And Vulo, of course, is very much on point here. You can't ignore the broader context of the allegations. You can't ignore the complaint as a whole. You can't pick one or two allegations here and basically assume that that's not right or assume that no one could ever conclude it. You have to take the...
You mentioned, you say the FCC's admitted use of race, and you challenge the district court's analysis of Article 3 standing to go against the FCC, and you argue that they have a policy of considering broadcast owners' race in the public interest analysis. Can you pinpoint what the policy is?
The FCC has admitted on the record, and there's guidance on this, that they consider the increase of diversity of media owners as one factor in its overall assessment of the public interest. Now, of course, the government has contested that infects its consideration of any individual deals.
Also, a lot of, this is like the, DEI, diversity, equity, inclusion, isn't necessarily tantamount to saying we make decisions or even that we consider race. Diversity can mean lots of different things. Not necessarily racial and not all racial. And as I read it, going back to Adirond, there's a constitutional prohibition against basing governmental decisions on race. So is there something more concrete?
Well, yeah, there's a few things that are more concrete. First of all, we have an allegation in this case that the FCC, at the objector's request, requested specific information about an alternative transaction, which is way beyond the scope of what their statutory authority allows them to do in the public interest analysis. And that alternative transaction was for Byron Allen, who's an African-American and whose deals have been approved without objections from these objectors.
But I was asking about a policy. That seems like some circumstantial evidence from which you're asking us to draw an inference that there was a race-based reason. But you refer to the FCC's admitted use of race, and you refer to its policy of considering race. And I mean, maybe you've already answered this question, that they reference an increase in diversity.
Well, so I would agree with you that diversity could mean a lot of things, but again, we're at the pleading stage here, so you have to draw inferences in our favor and you have to assume our allegations as what are true. I could have some more time to address the court questions. At that stage alone, I think we're sufficient. I don't think it's controversial to suggest that anytime you bring a racial criteria, allegedly cabined or not, that is going to increase the possibility of unconstitutional use of race. The SFFA case is a prime example of a situation where there was an alleged use of race that exceeded the bounds of what the Constitution provided. Or at the motion to dismiss stage, you have to take our concerns as valid. And if you needed if we needed to shore that up at all, which I'm not sure that we do, the fact that the FCC agreed and ordered Standard General to produce information about an alternative bidder, and only one alternative bidder, Byron Allen, who had also said he was still in the fight for Tegna, who had called Mr. Kim, who was still expressing interest in the Tegna deal as the case was falling apart. That is enough of an inference. I just want to also point out that we shouldn't get too hung up on the policy point. If you look at the Navy chaplaincy case that we cited here, a policy does not need to be an official policy. It just simply has to refer to a discriminatory process or discriminatory act, and we've easily alleged that here.
And does it matter to you that in terms of this FCC, standing to challenge the actions of the FCC officials that you accuse of wrongdoing in connection with this deal are no longer in office?
No, I don't think it does for two reasons. First of all, we've sued them in their official capacity, and so I don't think that their status as past employees necessarily reflects upon our ability to obtain future relief, because
But in terms of the likelihood of more action like this.
No, I don't think so. If that's a mootness argument, that was not raised below, and the standards for mootness are different than the standards for standing in the first place. And so that could be raised, but it was not raised below, and it's not before this court.
Well, what was raised below and what was part of the district court's decision was you have to show us likelihood of future injury.
Correct. And
you don't dispute that that's part of your burden.
We have to show a reasonable likelihood of future injury. Of course, I think even the district court acknowledged that a past incident of racial discrimination is a strong indicator of the potential for future discriminatory injury. This court's case say that. I'll go back to the Navy chaplaincy decision, which is very much on point here, and the defendants spend very little time discussing, because it specifically describes how the fact that there was alleged discrimination, which we have to accept as true, and the fact that you were going to be back in front of, in that case, the promotion boards for ministers in the military, was sufficient to allege future injury. Mr. Kim is going to be back in front of the FCC. No one disputes that. He is regularly in front of the FCC, and in the same way that the plaintiffs in Jabril, once they were, allegedly unlawfully stopped or targeted for being terrorists, the fact that they were likely to fly again was sufficient to allege future injury.
But it seems like the relevant question for those purposes would be not just whether you're going to find yourself before the same body again, which, as you mentioned, that may well be satisfied here, but whether the interplay of circumstances that gave rise to the injury is likely to recur. And it's a pretty complicated set of circumstances that gave rise to the injury here. It involves allegations of discrimination, but it involved the confluence of another bidder who was a part of a different racial community, and then there were some various things that had to happen in order for it to develop in the way that it did. And wouldn't we have to think about whether the complaint makes an adequate showing that that interplay of circumstances is going to, or that kind of interplay of circumstances is going to come about?
Well, I think, first of all, as we allege, the public interest analysis, which includes some of the racial discriminatory concerns that we have in this case, does apply to renewal of licenses. So I think that that's sufficient. This is if you look at Navy chaplaincy, you did not need to show that you would be going before the same promotion board. You did not need to show that you would inevitably be up against somebody who was from or from a liturgical Protestant community. It's sufficient to show that you suffered discrimination in the past, allege that you discovered discrimination in the past, and that you are likely to be back in front of the same decision-making body, which still is going to apply the same allegedly unlawful standard. We think we've done that here.
I may be misremembering, but aren't there other instances of license transfer applications by Mr. Kim that sailed through the FCC? I mean, this is just to the chief's point.
Yeah, so yes, the court put weight improperly on the fact that he had previously obtained FCC approval, and I don't think that's any more conclusive, especially at the motion to dismiss stage, than the fact that the Jabril plaintiffs, for example, were able to fly unmolested at some point until they were searched and barred from flying under the terrorist watch list. The fact that you did not suffer racial discrimination at a point in the past, once you suffer racial discrimination, accepting that allegation is true, it's very much reasonable to believe that all the...
I think the way that it factors in is this. At that level of generality, I don't dispute the proposition. I guess the question is this. If the racial discrimination that's alleged to be suffered is the product of a confluence of a number of circumstances, which is to say, it's not that the allegation is every time I come before the commission, I suffer racial discrimination. It's that I suffered it in that one instance because of the following set of circumstances. Then it seems to me that the question would be whether that confluence of circumstances is likely to come up again, because I don't think the complaint takes the position that every single time your client comes before the commission, there's going to be the prospect of racial discrimination that results in injury. Because that's not the set of circumstances that gave rise to the injury, nor is the set of circumstances that would potentially come about again that would potentially give rise to the same injury in another occurrence.
I suppose that's potentially true, but consider the SFFA and Grutter context, which we cite in our case, right? In those cases,
What was that considered?
the Grutter and the SFFA circumstances, right? In those cases, all the courts found that was necessary for standing to receive for injunctive relief going forward was that you were ready and willing and able to apply, and you would be subject to a process that could treat you unfairly. Now, it's always possible that when you went to apply, there weren't enough seats or there was a different, criteria being applied. But as long as race was one of the things that might be considered, that was sufficient for a future imminent injury in that case, and we think it's sufficient here. I don't want to skimp on the Norr Pennington argument, which was obviously a big focus of the briefs of the private defendants, and which again think is completely mistaken under the pleading standard for 12b-6. We have obviously argued that Norr Pennington doesn't apply outside of the antitrust or the labor context. I think the district court acknowledged that that's an open question under circuit precedent. Of course, this panel doesn't need to decide that question if it determines that we alleged the sham exception in our complaint. And I would just suggest that we easily allege the sham exception in our complaint. I don't think it's particularly close. There are a number of cases that we've cited. Israel from this circuit, the Lipitor case from the Third Circuit, the AT&T case, which involved an FCC case, and the landmark decision from the Second Circuit. All of those cases are very similar on their facts. That we have alleged both objectively baseless and a subjectively baseless reason for the petitioning activity.
In setting aside Norr Pennington for a minute, just looking at whether the complaint pleads intentional racial discrimination by the private defendants, you argue that you highlight as evidence of race-based animus references to shadowy foreign investors and China's escalation for Taiwan. But as I read those in context, they seem to refer not at all to Mr. Kim's race, but to the facts that investment funds financing the deal are headquartered abroad. And I mean, he's not Chinese or Taiwanese. So tell me, setting aside those statements, are there other allegations that support an inference of intentional racial discrimination?
Well, yes, there are.
Private defendants?
Sorry. Yes, there are. Obviously, there are allegations about coordination with Byron Allen, prior deals in which the same objectors did not raise the same concerns with respect to Byron Allen's deals. Prior deals, and this is on JA 53, paragraph 111 of the admitted complaint, where the objectors had not raised similar concerns.
I read those and I get those, but one way of looking at them is like, favoring people's politics. Like the thing that you really pointed to tie to race is this idea that there was some sort of like expressly anti-Asian sentiment expressed. And I take that reading about, I think I understand what your reading is of the shadowy foreign investors comment in that whole paragraph, but more that really clinches the deal about intentional racial discrimination.
Well, I guess I will answer the question, but let me just make one quibble with all due respect. Like the whole rub is that is one way to read it, but there's another way to read it.
No, I
and we're at the
understand your
12B16.
pleading argument about you draw inferences, reasonable inferences in light of the plaintiff.
And just as in Navy chaplains, they were Judge Tatel referred to sort of the long history of religious discrimination in this country. I don't think that this court needs to blind itself to what has happened, particularly with respect to Asian Americans, how they've been treated as outsiders or as foreigners. Again, the SFA case is a good example of that. But yes, we certainly have more. Again, it was the objectors who wanted, the private parties who wanted the FCC to demand that we produce alternative transaction information and only about Byron Allen. We have an allegation that the chair of the FCC laughed off the concerns that Mr. Kim raised and said you should hear what they say about you in private. We obviously have the connections between Byron Allen and his.
What do you think that means? We should hear what they say about you in private.
Well, I think that if the allegation was that the chairman expressed outrage and said that is just referring to hedge funds and that is just referring to things and it's not racist and nothing that they're saying is racially discriminatory, that would be one thing, but that's not the allegation. And like I said, I think that a government official in this case, but any defendant who laughs away a concern raised about racism, and again, we're not just guessing here. There was numerous public commentary at the time by former FCC chairpeople or FCC commissioners and others on both sides of the political aisle who very much believed that what was happening here, the inference to be drawn was that his race was being used against him in these proceedings. And again, he was being compared to a failed bid from an African-American communications person who was also still in the fight and offering to smooth things over at the FCC, whose lobbyist
Were there other failed bidders who were still in the fight?
I believe there were some initial bidders, but no one who expressed an interest and told the press that they were still in the fight, who called Mr. Kim after he was in front of the FCC and offered to smooth things over. Exactly. I mean, if this were in any kind of similar employment context, I don't think you'd have any problem. I mean, Hovey Garland is another case that we've cited that is, I think, very much on point with kind of what's sufficient to establish at the pleading stage. And again, I really want to commend the court on the North Pennington stuff to look at the last few pages of the Lipitor decision. Look at the decision in Landmark. Both those cases, by the way, I'll just note, included preliminary court orders for jurisdictional discovery in Lipitor. In the Connecticut case, the Connecticut Supreme Court had certified a case in both cases that eventually led to the abandonment of the licensing procedure, but that was not sufficient to establish that the concerns were objectively baseless for purposes of the sham exception.
You sure my colleagues don't have additional questions for you this time? We'll give you a little time for rebuttal.
Appreciate it. Thank you.
Good morning, may it please thank you. Good morning, may it please the court. Andrew Burney on behalf of the federal appellees. The district court correctly concluded that plaintiffs failed to establish standing to seek prospective relief on either their equal protection claim or their ultra vires claim based on the Communications Act. Although past legal violations aren't themselves sufficient to show a substantial risk of future injury, here plaintiffs failed to plausibly allege either racial discrimination or a violation of the Communications Act in the first place. And putting aside the absence of any credible allegations as to past injuries, the allegations in the complaint are insufficient to show a substantial risk of future injury. With respect to the past, the Tegna transaction, which is what this case is really about, I think plaintiffs face a number of independently insurmountable obstacles. Just to start with the most obvious one, the Media Bureau issued a painstakingly thorough written decision explaining why multiple issues associated with the transaction required a hearing. Now, in attempting to impugn that written opinion, I heard Mr. Strawbridge in his argument refer to statements by former members of the FCC, senators, objectors. The only alleged statement they've identified by anyone in the FCC is this statement, alleged statement, which we of course dispute was made by Ms. Rosenworcel on JA 86 at the November 22 meeting with Mr. Kim. Now, even assuming that she said what the complaint says she said, that statement doesn't have a racial dimension to it at all. It doesn't show that she had even seen the statements by the objectors that he raised that she agreed with Mr. Kim's interpretation of them, and I'll get to those statements by the objectors themselves in a second if I can, let alone that she shared their view, and then to say that that somehow impugns the decision of the Media Bureau months later, let alone furnishes a risk of substantial injury years after the fact, now that she's left the agency, even at the pleading stage, that's just multiple bridges way too far. So when you strip away just that statement, what you're left with for the most part is these statements by the objectors to which plaintiffs refer. Now, I mean, these aren't statements by my client, obviously, so maybe Ms. Kalin would want to object them, discuss them more directly. And our frontline argument, of course, is that these statements aren't attributable to the federal defendants in the first place. But I mean, if you look at those statements, Judge Wilkins, I took Mr. Strawbridge to agree that they're cited in and relied on the complaint. So of course, the district court properly considered them. I mean, my submission to you is if you look at JA 344 to 348, this is plaintiffs' response to the petitions to deny the applications, in which they really quite explicitly invoke race as a reason to approve the transactions and fault the objectors for not addressing it. And then you look at the objectors' response, starting on, I believe, page 389 of the JA, and they're talking, those statements say that what they object to is media concentration. There's just no way to read those statements as evidencing any negative use of race. As Judge Contreras noted, the allegations of racism just melt away at the slightest bit of scrutiny. And there's certainly no basis of reading those statements as so obviously racist that they're somehow attributable to the federal defendant, such to call into question its decision.
It seems like your friend on the other side says that what the district court did was fail to grant all inferences in favor of the plaintiff. And so to the extent that they can select quotes from a document and say that they support their inferences, the response is not for you to try to select other quotes and say, well, they support my inferences. What's your response?
So my response to that is twofold, Judge Wilkins. The district court was required to accept all well-pleaded allegations as true, but there are two things the district court is not required to do. The district court is not required to defer to plaintiffs' characterization of materials that are incorporated that flatly contradict those materials themselves said. And the district court is not, to the extent they try to attribute those statements to the federal defendants, that's a legal conclusion, not a factual allegation that's entitled to any deference. And here, the allegations are just plainly insufficient. Again, even if you credited their interpretation of those statements, to call into question the federal government's ultimate decision here. As to, I want to talk about this question of, is there policy? I was frankly, of considering race in the public interest analysis of individual applications, I was frankly a little bit surprised that they doubled down on this the way they did in the reply. If you look at the materials they cite at footnotes 29 and 30 at JA 50 in the complaint, those are clearly those longstanding materials which date back, I think, to 1978, and which they haven't actually challenged as unlawful in this case, involve things like setting limits on setting ownership limits on particular markets for a number of reasons, including to allow to allow access to non-traditional minority and female potential owners. That is markedly different that is quite different from considering the race of prospective acquirers as part of the public interest analysis in approving or denying individual applications. We're not aware of any such policy. They haven't pled any such policy. As to the naval chaplaincy case, I think that case is quite different from this one in two respects. It really illustrates the defects in the claims here. In naval chaplaincy, you had two things. First of all, there was statistical evidence showing that non-liturgical Protestant chaplains weren't being promoted at the same rates as other chaplains, but also the policy at issue in that case was acknowledged by the Navy and was quite specific. The policy was you had small members of 7 boards who all voted anonymously, who rated individual applicants from 0 to 100. And so any one member could essentially veto in secret a prospective chaplain with views he or she disagreed with. And that policy wasn't disputed by the Navy. So when you had the combination of those two things, that supported a claim of a substantial substantial risk of future injury. And you just don't have either of those two things in this case. Judge Pillard, you asked if it's relevant that the relevant officials have, in the case of Ms. Rosenworcel, left the agency. In the case of Ms. Saar, no longer oversees the Media Bureau. We don't think it's necessary for the court to decide this case. But to be clear, we do think it's relevant in the following sense. Obviously, if you have a case where, for example, a plaintiff seeks retrospective relief from an agency rule or regulation, it's not relevant that an official capacity defendant has left the agency. Similarly, if what you had here was a challenge to some identified policy that was being applied prospectively in the future, again, the fact that the official capacity defendants have switched wouldn't be relevant. But here you have very specific, here you have allegations that a specific FCC and specific FCC officials at a particular point in time, based on animus towards Mr. Kim or racism or other impermissible considerations, affected the pocket veto of this transaction. I mean, Ms. Rosenworcel, for example, is mentioned, I think, more than 90 times in the operative complaint in this case. So in light of that kind of claim, it is obviously relevant that we have a very different FCC today, and that those two officials will no longer be involved in any future transactions that plaintiffs in the future. Judge Srinivasan, I think you're right to say that as I took your question to Mr. Strawbridge to indicate that this transaction had a particular set of features that even putting aside the weakness of the allegations of past discrimination just don't apply here. The transaction Mr. Kim points to at JA 158, there's no allegation that there's any competing buyers for that possible transaction, that Mr. Allen in particular involved. And so when you combine that with the fact that, again, the relevant officials have left the agency and the weakness of the past allegations of discrimination, I would think that's just plainly insufficient to show a substantial risk of future injury. Just briefly on the Communications Act claim, and then I'll sit down. As we we think that claim really fails for any of four reasons. First of all, any of which is sufficient. First of all, we don't think there's, to the extent that that claim is based on the September 2022 document request, there's no claim that that request really injured plaintiffs in any way, since the hearing designation order did not rely on alternative buyers, let alone Mr. Allen in particular. Just doesn't discuss that at all. There's also the reason the district court gave, which is also right, that to the extent that request was aberrational, there's no evidence that it'll be repeated, let alone to plaintiffs. There's the reason the district court also gave, which is that is not a collateral claim and it's barred by the Hobbs Act exclusive review provision. And finally, even if plaintiffs were to overcome all of that, what it would be left with is an ultra vires claim, which is one of the highest standards known to the law. Plaintiffs must show a blatantly lawless, a violation of a clear statutory mandate. Here, what you have in that request is one parenthetical as one subpart of an 11-part request for documents. It clearly, the literal language clearly is just referring to transactions among the companies, even putting aside that Section 310D doesn't restrict, let alone clearly restrict, the information the agency can request as opposed to what it can rely upon. So that claim clearly fails on any number of reasons. And if the court has no further questions, we would ask that the court affirm the judgment.
Thank you, counsel.
Thank you.
Cowan.
Good afternoon, Your Honors. May it please the court. Michelle Callan on behalf of the 10 private appellees in this case. I'd like to address plausibility, which is where most of the discussion from my friend on the other side addressed. But before getting into that, I'd like to begin where the district court focused, which is petition clause immunity. There's no dispute here that all of the activities that the private appellees engaged in here, meeting with agency officials, submitting letters to an agency, that all these activities involved some form of petitioning the government. Now, appellant's main contention is that the district court erred in applying petition clause immunity outside of the antitrust context. But this court has already held in the Venetian Casino case that petition clause immunity and the Noor-Pennington doctrine is a direct consequence of the First Amendment itself, not any sort of consequence of antitrust law or the Sherman Act.
Yeah, but we also have law reconciling equality, statutory requirements and constitutional requirements with First Amendment rights that allow a determination of intentional prohibited discrimination to include speech, even though speech would otherwise be constitutionally protected. And I guess, there are carve-outs from Noor-Pennington for libel, slander, defamation. And to say that it nonetheless should apply to intentionally racially discriminatory speech. Let's say the private defendants here had gone en masse and said, don't you dare let, this individual get a big contract. I don't want to articulate, gross racial stereotypes or epithets, but they say, he's a member of such and such an ethnicity, and those people are low down and can't be trusted. And, and then the government responds. It just seems to me like not necessarily obvious that the petition right wins out over private parties fueling government decisions and causing them based on intentionally racially discriminatory reasons.
Sure. So it does in private civil litigation, Your Honor. So in the situation that Your Honor contemplates, there's a regulatory regime whereby to seek direct appeal of an agency who engages in that sort of behavior. And that's precisely the sort of situation where there's an appeal to the full commission and then an appeal ultimately to this court through the traditional regulatory process. But the correct approach to rectify that sort of situation is not with civil litigation because there is the petition clause immunity. And there is room in the petition clause.
There's civil litigation all the time that alleges fraud. And I don't think there's a petitioning out to a fraud allegation.
That's correct, Your Honor. That's where the sham exception would fit in, right? Because in a fraud situation.
And part of the sham exception could fill that, but it's also, I think, just a generally recognized notion that you don't have to go through Noor-Pennington and fraud. Noor-Pennington and sham when you have a suit that's predicated on fraud. It just seems like there's not a First Amendment defense to fraud allegations. There's a merits defense to fraud allegations, and you were going to get to the merits point, but it just strikes me that this kind of complaint, the first thing that leaps to mind isn't that this complaint can't go forward because of the First Amendment. It may be that there's some problems with the complaint's allegations that would prevent it from going forward based on the nature of the allegations that are being made and why they don't suffice to get past the 12B6 bar.
So the second part of that is certainly true, Your Honor. The complaint here does not sufficiently meet the plausibility pleading standard. But because it's undisputed here that all the activity that's being engaged in is petitioning, there's no plausible allegation of fraud. There's no plausible allegations that overcome the sham exception.
Why don't you focus on whether there are plausible allegations that allege intentional racial discrimination or national or ethnicity discrimination?
Certainly, Your Honor. As to the allegations of discrimination, the allegations here take isolated snippets of statements entirely out of context and piece them together in a way that materially misrepresents the content of those statements. So to just one example that Your Honor, Judge Pillar pointed out when my friend on the other side was before this court was the allegations about the Taiwan Strait, which arise from a letter that a lawyer had sent to the commission in petitioning the government on behalf of clients, referencing geopolitical conflicts. It references the war in Ukraine, and it references geopolitical tension in the Taiwan Straits. And that's part of an advocacy for the FCC to consider whether or not there's foreign investment here such that there could be foreign influence on the media. These are all traditional considerations that the FCC engages in part of its process.
The FCC has obligations to look at foreign ownership, right? That's part of the part of the statutory requirement?
That's correct, Your Honor, as part of the public interest standard. So the allegations here simply come nowhere near the sorts of level of plausible pleading of some sort of racial animus at issue here. I'd like to just address one point, though, on the consequences of rejecting the petition clause immunity argument here, because when it comes to allegations of a conspiracy like the allegations that are set forth here, if there's the ability to attach liability and allege this sort of threadbare conspiracy, rational actors will think twice before they come to an agency and advocate in front of an agency. This sort of advocacy is precisely what the petition clause immunity is designed to protect.
They thought twice before using racially charged terms or saying things that could be construed as reflecting racial animus. Would that be a loss? Would that be a chill that we should be worried about for First Amendment reasons?
I think so, Your Honor, because the First Amendment doesn't just protect speech people like. It protects all kinds of speech, and it can protect even speech that people don't like. But I think here in particular, when the speech is so severely taken out of context in order to manufacture some sort of conspiracy, there's the concern that
sort of a merits argument about whether it's plausible in these allegations, but assume that it is entirely plausible. That the John Birch Society comes in and says to the FCC, you really need to deny, Mr. Kim or Mr. Allen or anyone for reasons of race, ethnicity. And the FCC says, good idea. We hadn't thought of that. And they act. Petition clause applies to the private defendants. I mean, I guess you could have a claim against the FCC, but private defendants protected by the petition clause?
Yes, Your Honor, because that is the scope of the First Amendment and First Amendment immunity. It applies even to speech we don't like. And in the context of petitioning the government, if the government were to accept that's representation and then make a government decision based off that representation, especially in the agency context like here, there's the traditional agency appellate review. And I'll note that but
it doesn't protect them if they were employers and they were directing a hiring team the same way. There's no, and if it's a public employer, there's no First Amendment reason that you couldn't say, that speech supports a finding of illegality under Title VII or.
So I think if it's petitioning the government, then it is protected speech absent the sham exception, Your Honor.
Sham, not including intentional racial discrimination?
So if it's intentional racial discrimination that meets the standard in the sham exception, then that's where the petition clause immunity does not apply. And that the district court properly applied the Noor-Pennington test in order to answer that question. Is this petitioning protected under? It's
not a jurisdictional issue, right, Noor-Pennington? So it is not something that actually has to be addressed.
That's correct.
Good.
That's correct, Your Honor. The court has no further questions.
Sure we don't? Okay. Thank you, counsel. Mr. Roberts, we'll give you 2 minutes for a rebuttal.
Sure. I think that the court should be a little bit, at least give some equal weight to the consequences of applicants for FCC transferred licenses being subjected to racial discrimination and the effect that that might have on their willingness to come forward. Indeed, there's allegations in the complaint that Mr. Kim has had to structure some deals differently in order to avoid the racial discrimination that happened here. There's a lot of discussion about the terms in the letter and how any reasonable person reading that letter can infer any racial discrimination. I think the court understands our argument on that and the fact that some of that stuff could be read to refer to Asians as outsiders, but I want to talk about all the other evidence of racial discrimination here that I think standing alone would be sufficient to get us past the 12B6 hurdle. First of all, you have the fact that they're not supposed to compare people to other transactions, and they issued a request at the objectors, urging
for alternative buyer information, and they specified that the only alternative buyer transaction info that they wanted was from Byron Allen, the same person who had previously bid, who was still in the fight, who had connections to the Good Friend Group and all the other private defendants. We allege that the objectors in this case did not object to the Apollo Cox deal. Even though there was Cayman Island funding in that, there were no shadowy foreign individual references in that case. We note that none of the objectors objected to the two deals that are cited in the complaint regarding Byron Allen. We've obviously alleged that the FCC precedent barred the concern about retransmission fees and barred the concern about newsroom consolidation or the loss of jobs as improper for the FCC to consider. And the policy at the end of the day, it's not just a diversity policy, it's a minority ownership policy. And the allegation here is that they were comparing Mr. Kim and treating him differently than they would have if Byron Allen had been the proposed purchaser. And there's plenty of allegations that support that as to all of the defendants. I thought it was telling that the government's attorney felt the need to, my friend on the other side, felt the need to start with the merits of the case instead of accepting the allegations as true and dealing with that. I do think that he misstated the 310 argument as the district court did. We're not challenging the request for information in and of itself, although that was not a final order and we had no opportunity to pursue that at the FCC. We're challenging what 310D specifically prohibits, which is the comparison of the applicant to another alternative transaction or another alternative buyer. That's what's prohibited. And the request for information is probably the most blatant example of the FCC departing from its policies in favor of a person of a different race who was interested in the deal, who was still in the fight for the deal. So I think that that's more than sufficient, even if you ignore the letter, which of course we don't. And that's why so many people from so many different backgrounds, as alleged in the complaint, felt that Mr. Kim was being treated differently because of his race by both the FCC and the private parties. Obviously, Judge Ballard, you're correct. The First Amendment is not any kind of absolute defense in this case. We actually do allege misrepresentation. The district court rejected our misrepresentation claims that we had not come forward with a material fact. That's obviously the wrong standard. That's the summary judgment standard, not the 12B6 standard. We alleged that the objectors continued to complain about Mr. Kim's intention to cut jobs when he had previously been told multiple times that that was TEGNA's pre-existing management policy. That's in the complaint.
I'm sure my colleagues don't have questions from you. Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Please. This court now stands adjourned until later this afternoon at 12:00.